Yes. First of all, thank you for your written submissions, which I have read. Yes, I've read. They're very helpful. I think in relation to each of the representations, which I think is where we're going to be going to quite shortly.
Yes.
You can take it that I've got the general points which are on board.
Yes.
I think it'll be necessary to look at some of the detailed points you make and not others, if I can put it that way.
Yes.
Perhaps it also seems to me that unless I've got this case completely wrong, some of the representations are rather more important than the others.
Yes.
But I may sort of move you on occasions.
Of course.
That's not because I haven't taken account of what you've done. It's just
Yes.
that I'm fairly satisfied that I've got the point you're making on board. Perhaps
I'm grateful, Your Honour. That was part of what I was intending with the written outline submission.
Yeah.
Because if Your Honour has the point and wouldn't be assisted further,
Yeah.
then I can move on and
Yeah.
finish quicker. Your Honour, just whilst we're on that, would it be helpful to have a hard copy of it? I have available a spare copy. If Your Honour
actually,
would like.
well, why not? I may look at it. I'm pretty confident I'll be working
Yeah.
electronically, but why not?
It's just what I'll do is effectively follow the guidance.
Thanks. And just before we start, let's just make sure I've got the document up. Yeah. Yes, very good. Thank you.
Thank you, Your Honour. Well, Your Honour, just before I do move on to deal with the oral representations, I did say yesterday I would have identified some examples in
Yes.
Mr. Ali Ibrahim's and Mr. Malaika's evidence that I say goes towards the themes of why their evidence was unsatisfactory. That is at subparagraphs 3 and 4 to paragraph 13 at page 4 and 5 of my outline submission. I don't propose to read them out, but
Yes, I looked at those. By all means, go to any of them that you want to, but I have looked at those.
yes.
Sorry, when I say I've looked at them, I've looked at what you've written about them. I haven't gone back and checked the references.
Yes, yes. Your Honour, I think where I will start is with the oral reps. I think if Your Honour has looked at those examples, I'm not sure making the points there are going to be that helpful.
No, just before you go on to the oral reps, at paragraph 14,
Yes.
you've got the adverse inferences in relation to Mr. Zographos,
Yes.
and we discussed that yesterday. Is there anything more you want to say about the other two individuals that Mr. Adair invited me to draw adverse inferences about?
Yes. Again, I'm not precise on the inference being asked.
Leave that to one side. I mean, I think
drawn.
his
Yes.
better point is that at least in one case you've got an employee who's still employed
Yes,
by you.
Mr. Limonarco, who attended the meeting on the 23rd of January. What I would say in respect of Mr. Limonarco, Your Honour, of course we have not called him that. He is still an employee. But he attended one of the meetings, and the purpose of him attending that meeting was in respect of other products. It was in respect of other investments.
Is that in evidence?
It's in the emails. That's why he's going
Right.
with them. And the representations that are said to have been made at the meeting are specifically in relation to Mr. Ali Ibrahim's evidence, which is I wanted to put Mr. Zographos on the spot and ask him questions about the funds. And he says that Mr. Zographos is the one who made all of these representations, not Mr. Limonarco. And in respect of Mr. Akka, it's the same thing. He turns up to talk about real estate investment opportunities, and what Mr. Al Ibrahim says happens is, well, after that meeting with other individuals, and he wasn't involved in it, he has a 10-minute conversation with Mr. Zographos, at which these representations are made. And it's something I will take Your Honour to as part of my submissions.
Okay, two things. One, can you just identify the emails you're referring to? Not now, but at some point before you close today. I'm sure I can find. Well, I think I know the ones you mean, but
it's F128.
Thank you. Secondly, just looking at Lemonarco in particular, it seems to me that if one looks at Lemonarco, on what you say, he's someone who was at the relevant meeting. He, however, was not attending for the purpose of dealing with the particular matters which are the subjects of the representations, and therefore, as it were, looking at the matter logically, it seems to me that the only inference which one could draw from him not attending is that he doesn't have evidence which would positively support your case, because otherwise you would have called him. But you would say, well, if I draw that inference, that doesn't really help, because you wouldn't necessarily expect him to have any evidence which positively supported your case.
Exactly.
And so
it wouldn't help you in my submission in what Your Honour's assessment has to be and the finding of fact that you have to make about whether that representation was made.
And I mean, just contrasting this with Mr. Zographos, if Mr. Zographos was employed by your client and he didn't call to give evidence, the inference might be that not only did he not have any evidence which possibly would support your case, but he had no evidence which would contradict this case, which is rather different.
That is different. I think that's a fair way of putting it, Your Honour. Mr. Zographos, if he was still employed by Ribble.
I mean, for example, one would expect him, even if he had no recollection, to say, well, I wouldn't have said this.
Yes, quite. And we see that with Mr. Swats and Mr. Bitcon, who both did come to give evidence about the meeting that they attended. And even though they don't recollect certain statements being made, what they do say and what they are able to say is, well, this is why it's inconceivable that I would have said it.
Yeah, so, all right. So, I mean, what it then comes down to is whether or not in the case of Mr. Zographos, take the view that there ought to be a positive reason for him not to give there, and the fact that he's not there isn't insufficient in relation to Mr. Lemonarco. All right, yes, that's helpful. That's helpful. Yeah, I understand how you put it. Right, oral representations.
Yes, I'm grateful, Your Honour. Your Honour, sorry. Your Honour, if I can just, Mr. Jackson's helpfully dug out the references, if I can just give them before I move on. F143 is...
So what are these references to?
They are the emails which show what the purpose of the
fine.
meetings were for these individuals attending. So F143 is in respect of Mr. Lemonarco.
Yeah.
And G1522 is in respect of Mr. Acker.
G1522. Yeah, okay.
Thank you. So my third topic is the alleged oral representations, Your Honour, which starts at paragraph 15 of my note. Now, I will come to deal with each of them individually, or insofar as Your Honour wants me to deal with any specific ones and not others, that's what I'll do. But there's three overarching points I would like to address you on before that, which I say frames the context in which it's alleged these representations were made. The first point is that we say there is a conspicuous lack of any documentary evidence recording that these alleged oral representations were ever made at these meetings. Now, there are 4 meetings that took place. There is one document that has been produced by ALAWWAL, which is in respect of the 23rd of January meeting. And that's described initially by Mr. Ali Ibrahim in his witness statement as minutes of the meeting. However, when I cross-examined him on that document, he did accept that, well, this is not something that was produced and shared with the RIBL representatives who attended, or that they commented on it, or that they approved it. I think, in fact, he went as far as to accept that it was not an accurate record of the 23rd of January meeting itself. Because, for example, it doesn't detail the discussions about the other investment products, which is what the RIBL representatives thought they were turning up to do. And Your Honour, if I can just go to F128. This is the email that precedes the meeting on the 23rd of January. We can see below, we've looked at this before, but we can see below that Mr. Ali Ibrahim is requesting some information about 3 other investment products, and that Mr. Zografos replies saying, please find attached the relevant information. Thank you, and look forward to discussing these on the 23rd of January. Now, there's more to the evidence about what the purpose was and how ALAWWAL wanted to treat this meeting, which I'll come on to. But what the minutes of the meeting, or purported minutes, appear to be is just a summary of a separate internal meeting that took place between Mr. Ali Ibrahim and his team. So we say that Your Honour can't really place much reliance on that as being an agreed statement or recollection of what was discussed at that meeting, or that it is in fact evidence of what the RIBL representatives say. More generally, there are no contemporaneous emails whatsoever which confirm or even support the existence of these alleged representations. So, for example, there's no emails from ALAWWAL to RIBL prior to the meetings setting out an agenda or saying these are the questions I want to explore with you, please come prepared for it. There's no emails that follow the meetings saying, well, you've made these representations, I intend to rely on them, can you please confirm these are accurate? And in my submission, the absence of any documentary evidence recording the alleged representations suggests both that A, the representations themselves were not made, or that if they were made, they were not relied upon by ALAWWAL in deciding to invest in the fund. Now, the second overarching point I wish to make is that in my submission, the nature of the meetings themselves provides a strong indication that no actionable representations were made. These were, in my submission, short marketing meetings with no prior agenda, at which RIBL was delivering sales pitch and trying to give information about the fund and them to ALAWWAL. And in that context, neither party, in my submission, can reasonably have understood that any actionable representations were being made. Now, just to be clear on that, Your Honour, what I'm not saying, and I think Your Honour raised this point yesterday with Mr. Adair, what I'm not saying is that just because Mr. Zografos was a salesman and is the one that turns up, that means no actionable representations could be given. What I am saying is that the nature of the meetings themselves, so we take the first one on the 14th, an introductory meeting, for example. We take the one on the 23rd, we say he's turning up for another purpose, he doesn't quite know why he's going or whether he's discussing the fund. That lends itself more to what we would call sales talk, the art of the sale, selling the company, talking about how wonderful the fund and the investments are. It lends itself to that, and we say those are generally sales talk. They're not intended to be actionable, and it's not understood by ALAWWAL or anyone that actionable representations are being made. And Your Honour, I would say that there are some documents which in my submission support that contention. If I can take, Your Honour, just to one example of it, possibly the best example of it, it's F30. Again, a document we've looked at before. This is an email from Mr. Zografos to Mr. Ali Ibrahim following the first meeting. on the 22nd of November. He says, "A real pleasure to meet you last week in Saudi, and thank you for your time in the meeting. As per our discussion, I will be sending you an email shortly with further details about next steps with the draft agreement between us. In the meantime, I wanted to share with you the presentation prospectus and the most recent fact sheet." So just pausing there, what he is doing is, in my submission, what salesmen do, which is you go, you have the general meeting, you do the introductions, you pitch how wonderful everything is, and then you follow it up with documents that are actually providing the information. And then he says, "I want to check sometime next week for a call with the fund manager to further clarify any queries you may have." And in my submission, Your Honour, that's indicative of the fact that Mr. Zografos was a senior salesman, yes, but one who is there to market the investment. He's not the guy who's got the details, who's going and giving you the hard-hitting answers of this. These are statements you can rely on. You're coming to me with due diligence questions, specific questions, and I've got them. What he's saying there after the meeting is, if you have queries about the fund, let me put you in touch with someone who actually knows what it's all about, beyond what I would as a salesperson. So that's why we say the nature of the meetings and the fact that Mr. Zogfors is free of them and alleged to be the one giving the representations is important. And Your Honour, I refer to Cartwright on misrepresentation, which I took you to in the opening. I don't propose to do that again, unless it's helpful, but it's at 15.2. Now, going to the individual meetings themselves, I've set out at 15.2, starting on page 6 going into 7, what I say about the 14th of November meeting. And Mr. Ali Ibrahim's evidence is fairly important on that, and I've set out the examples there. And Your Honour, I've given the reference to the transcripts there, but what he says is that this was the first time he had ever spoken to Mr. Zogfros, and it was the first meeting. He says that ALAWWAL hadn't sent any questions or information about themselves in advance. It's described as an initial introductory meeting at which Mr. Zogfros delivered an opening sales pitch. He also said that Mr. Zogfros just merely repeated what was in the PowerPoint and didn't go beyond its contents. And then he also said, importantly, that he only relied on anything Mr. Zografos said insofar as it matched what he was seeing in the fact sheet and the PowerPoint. So the context of that meeting, based on Mr. Ali Ibrahim's evidence, we say makes it improbable that any actionable representations were actually made. In respect of the 23rd of January meeting, and that's at sub B on page 7, again, no questions or agenda was sent in advance of this meeting. We've just looked at the email where we see the queries are about different investments. Mr. Zogfos sends through the information and he says, "I look forward to discussing it with you." And that's consistent with Mr. Ali Ibrahim's evidence, which is he says, well, I wanted Zografos to turn up and I wanted to put him on the spot. I wanted him to turn up and I wanted to put him on the spot about the research and the analysis that me and my team were doing. So from Mr. Zografos and Ribble's perspective, he's not going into this meeting expecting to discuss the fund or for anything to be said about the fund and for those statements to be relied upon. He's going to a meeting prepared and ready to answer details about the fund, and then he's being asked fairly, what I would say, are fairly detailed and analytical questions about standard deviation and the Sharpe ratio and so forth. And we say his ability to make, as it were, actionable representations on that, or to give any statements or information of detail is likely to be limited. And that's supported by the email we just looked at, where he says, if you want to discuss queries, I'll put you in touch with the fund manager. In respect of the 6th of February meeting, this is the big meeting where everyone, or at least 2 senior people from ALAWWAL side and I think 5 or 6 from Ribble are there. What the documentary evidence, again, for that shows is that there was no specific agenda or question that was set. And it was asked. Mr. Zografos did ask Mr. Ali Ibrahim. It's at F155. He asked, is there anything you want to talk about? Is there anything your senior executives are coming here to talk to Ribble about? And he says, no, it's just part of our due diligence into the fund. So he doesn't set any agenda, he doesn't set any questions on which Ribble are coming in expecting to give answers. And the meeting was attended by Mr. Malika and Mr. Awan from ALAWWAL side, neither of whom had met any representative of Ribble before. Mr. Malika, in my submission, was particularly unhelpful on this point because he kept trying to suggest, in effect, that he had met someone that he hadn't, and he may have just ran into Mr. Monaco, but he can't remember if he met him, and so forth. So we say this is, this meeting was an introductory meeting for the senior executives with some of the senior executives of Ribble, and it's a meet and greet. And it was an opportunity, and the focus of the meeting was for Ribble, again, to deliver the PowerPoint, which we say is generic marketing presentation that's communicated to every prospector. It's not tailored specifically to ALAWWAL or their requests. And in respect of the 25th of February meeting...
I mean, the 6th of February meeting, F155,
yes,
they are being told that it's in the context of their due diligence. I say they, sorry, your clients being told, because Mr. Abraham Radigan agenda kindly notes the visit is a part of our regular due diligence about RASMALA and its trade finance fund. Definitely happy to discuss any chance where we can improve our partnership with RASMALA. So what they're being told is this is in the context of due diligence. So they're not being told we've got specific questions, but they are being told effectively, look, what you tell us is important in the context of our due diligence.
well, what they're being told is this is part of our regular due diligence. But what does that mean? What does it actually mean? You're telling me you're coming to do regular due diligence, but what does that mean? Are you coming here to see what?
Well, I mean, you're right, it doesn't give any information.
Yes.
But it suggests, effectively, we want to buy your fund, but we want to understand what we're buying. I mean, it doesn't take it any further than that.
Yes.
But I mean, it certainly, I would have thought, is inconsistent with the idea that this is just sales pitch stuff. It's a meeting where, well, maybe not inconsistent, but certainly it's difficult to say that anything said here doesn't matter. If I can put it that way.
I would agree with that, Sean, and I'm not saying that it's. I would, of course, disagree that it's inconsistent, and I think Your Honour takes that point as well. But the point that I'm making is that we have to understand the context of the meeting and what Ribble is going into. Yes, they are being told this is part of our regular due diligence, but they don't know what that due diligence is. They don't know where the focus of ALAWWAL is. They don't know where their questions are in respect of. And
it seems to me, though, that a fair way of putting it is that this is a meeting at which they're meeting a prospective investor in a fund of which, well, they're the investment manager, let's put it that way.
Yes.
They have an association, and the client's got some questions. I mean, that's what it comes to.
Well, it doesn't. I take Your Honour's point, but again, this email doesn't say it's got questions. It says it's part of our regular due diligence. And then what Mr. Malika's evidence is in his statement is actually one of the reasons he wanted to go is he wanted to get a sense of the calibre of the people that are there. And if you remember the investment process, I can dig it up, Your Honour. One of what is said about the due diligence that ALAWWAL is going to take as part of setting up his fund is just that it's a site visit. To the manager. So again, that doesn't indicate that what the meeting is about.
No, I mean, I'm fair. Okay.
Yes.
So you move on to the 25th of February.
Yes. But in any event, where the dispute about this meeting comes, Your Honour, is Mr. Malika says, well, I asked these questions and these are representations that were made. And we say, or our evidence is, of our witnesses is that, well, they don't recollect many questions being asked. They're not saying none were asked, but they don't recollect the questions being asked as they are said to have been asked. And they don't recall making the representations, and they explain why those representations wouldn't have been made. Where the two parties are consistent is that both sides say, well, the focus of the meeting and what was done is you went through the PowerPoint presentation. So again, that doesn't suggest that these representatives from ALAWWAL are turning up with a list of questions. Okay, I've read everything. I'm now going to ask you 1, 2, 3, 4. If they actually accept that what has happened is they've gone to the meeting and there's a dispute about, Mr. Stewart says it's about an hour, Mr. Malika says maybe 90 minutes, maybe up to 2 hours. But both agree that the focus of it was going through this presentation. So again, the meeting is not a specific Q&A there. It's they've turned up, and what they've allowed Ribble to do is go through the presentation that they've already been sent and effectively to run through what's in there. And there's an incredible level of detail in Mr. Malika's statement about, we went through each slide and this person said this about this slide and this person said that about that slide. And I would say that that's just not credible for a witness to recall that level of detail about a meeting that happened long ago. And we're all familiar with the cases, but also the theories that the more flesh, the more detail you try to add on to the bone about evidence of things that happened a long time ago, the more likely it is to be untrue. And when I pressed him on this, his evidence was, well, I didn't remember a lot of this. I had to go through and check my tickets, my itinerary and everything, what I was going to do. So he didn't remember any of that. He had to go and check it. He also didn't remember that he had another meeting with another fund manager, another investment manager, in respect of which his firm ultimately made an investment. He was going out of his way to say, no, I remember this because it was about Ribble. That was the whole point. In effect, he was trying to say, I was drilled down, focused into Ribble. That's why this is so memorable. And that's just not true. When I took him to the evidence, he was eventually forced to admit, okay, yeah, I may have had another meeting with AGC. I may have had other meetings, I don't know. So we say the unnecessary details that are there are merely details that are being added to try and add credibility that he has a good recollection of this meeting. We say that's not credible. Now, in respect of the 25th of February meeting, Your Honour, that's a slightly different category altogether, because what we do know is by the time we get to that 25th of February meeting, the BDC, the day before, has already approved the due diligence, as it were, and has agreed to start making the investments into the fund. And that's something that Mr. Ali Ibrahim confirmed in his evidence. Your Honour, would it assist you for me to take you to that minutes, just to make that? We have looked at it before.
Sorry, which minutes?
The BDC minutes of the 24th.
No, I don't need to look at that.
Yes. So we say that the decision to actually begin the investment has already been made the day before the meeting. So what is it that they are saying they've relied upon in that meeting? But in any event, Mr. Ali Ibrahim's evidence on that and the documentary evidence on that shows that that meeting was being set up for real estate funds. And Mr. Ali Ibrahim says, well, I had a 10-minute conversation with Mr. Zografos after that. And these very specific, detailed bullet point representations that I can give you were unequivocally made in that 10-minute slot. Again, we say that's just not probable. The third overarching point, Your Honour, that I want to make is that Mr. Ali Ibrahim, and this isn't sub-3 of page 8, Mr. Ali Ibrahim confirmed in his oral evidence that he would not rely on what Mr. Zografos, as a salesman, was telling him, and he would instead rely on the documents produced by Ribble. That's what his evidence is. Now, Your Honour, it might be worth just taking a look at that in the transcript. It's day 2, page 168, lines 8 to 12. So it starts off on 167, but the question is, so you should rely on what the investment manager has produced. You shouldn't rely on what Mr. Zografos tells you. Is that what you're saying? Zografos confirm what is mentioned in details and example of discussion. I understand. This is what I'm saying. So you knew, as it were, an investment manager document is what you're going to rely on as opposed to what the salesman is telling you. Yes. Now, the relevance of that is that insofar as the alleged oral representations are said to have been made to Mr. Ali Ibrahim by Mr. Zografos, which would cover all the oral representations at the 14th of November meeting, 23rd of January meeting, and 25th of February meetings, we say ALAWWAL cannot have understood them to have constituted actionable representations on which it should rely on the basis of Mr. Ali Ibrahim's evidence. So, Your Honour, with that, those kind of overarching comments to make, what I'll do is move to address you on the individual alleged oral representations. There are 7 in total. I will be guided by Your Honour as to which of the ones, if Your Honour wants me to move on from it. The first one is the oral client representation.
What I'm going to do with these ones is just, I've got the amended particulars claim, I'm just going to have
in front of me
sorry, you've given me the references, I'm just going to make sure I've got the terms which are pleaded so I can have clearly in my mind what it is that's being alleged. Yeah, okay.
The references are in
Yeah,
my...
no, I've got, it's all right, okay, yeah, go ahead.
Yes. Sorry, Your Honour, if you can use... Yes, sorry, page 11. So, Your Honour, this is that the fund only entered into transactions with reputable clients. It's not an allegation that we admit. And what we say in respect of that is that because we don't admit it, it is for ALAWWAL to prove that it was made, and that the evidence is insufficient to enable it to do so. But if Your Honour was minded to find that such a representation was made, in my submission it represents a generic and not an objectively verifiable statement. And we say, therefore, it constitutes either sales talk or possibly a statement of opinion, but it is not actionable. And there's 4 points that I make in support of that. The first point is that Mr. Ali Ibrahim's evidence is that in making the representation, Mr. Zogfros merely repeated what was contained in the fund's PowerPoint presentation. And Your Honour may recall, I can take you to it if it would be helpful, but Your Honour may recall the language in the PowerPoint is very generic. It talks about the fund will invest in transparent trades with established reputable companies. It will engage in robust due diligence, and it's with companies with reputable long track records. So very, in my submission, generic language. But importantly, Mr. Ali Ibrahim accepted in his cross-examination that the words reputable client and long track record can mean different things to different people. And I would say he's obviously right on that point. So there's no identified criteria here that actually allows ALAWWAL to understand what is meant by it. So by its definition, the representation is something that's not objectively verifiable. Now, the next point on that is that the fact that this is general kind of sales talk, generic marketing material is confirmed in my submission by the fact that this is being said by almost every other investment manager who is marketing a trade finance fund. And I give an example of this at 16.3e at page 8 in the EFA DDQ that they produced. And we say it's self-evident that no investment manager is going to say that the fund contracts with disreputable counterparties with no track record. So the alleged representation is very generic in nature if it's been made. And it merely states what one would already assume to be the case. So we would say it's not actionable.
I mean, presumably, and you're coming on to this, I think, but in relation to falsity,
yes.
We only enter into transactions with reputable clients with a long track record, which is what one's looking at, is so far as the long track record is concerned, probably a representation that who we believe are reputable and have a long track record, and possibly that we have have reasonable grounds for believing that, or possibly there is nothing which leads us to suppose they don't have that. One of those. Just assume that in Mr. Adair's favour.
Yes.
When it comes to falsity would have to be more than simply showing that retrospectively they've entered into a transaction which has gone wrong. It would have to be something which said that at the time it was made, either they didn't have reasonable grounds, or there were the following matters which should have led them to believe that they wouldn't give it. Now,
Yes.
I assume that's a point you made.
That's correct, Your Honour. Yes. Well, we can look at it and test it by reference to what they do say, because the allegation in respect of falsity on this representation is in the particulars of claim at 66.3,
Yeah.
which is at page 35.
Yeah.
So at the bottom, I'm sure Your Honour has read this many a times, but the only basis upon which ALAWWAL pleads that the oral client representation is false is that there are English High Court litigation proceedings against Trafigura by the fund, in which the fund has alleged Farlin used forged documents to induce the fund to lend. Now, in my submission, that provides no basis for the inference that the fund did not contract with reputable counterparties with long track records for 3 reasons. The first is that the alleged representation relates to the fund's general approach to dealing with counterparties, not its approach in respect of one specific counterparty. So this case isn't about just if Farlin is not a reputable counterparty with a long track record, therefore you haven't complied with, or you haven't acted in accordance with your representation. And what I say is that even if it were established, for example, that Farlin was not a reputable company with a long track record, that would not mean the representation is false in the sense of the fund did not generally contract with reputable counterparties. The second point that I make is that the mere fact the fund was deceived by Farlin would also not mean that the representation was false. It's inherent in a fraud that a fraudster is going to
I think you'd say that
conceal.
it goes against the points I was putting, is that if someone's deceived, it's just that they didn't have knowledge of it rather than having or ought to have had
Yes.
knowledge of it.
Exactly, Your Honour. And the last point that I make, which goes to the point Your Honour and I were discussing a moment ago, is that even if the court in England was to find that Farlin had forged these documents, that would not mean that the fund's subjective assessment of Farlin as a counterparty
I'm not sure
at the
that
time.
isn't a different way of putting the same point we've just been discussing.
Yes, exactly.
Yeah.
So Your Honour, I say on
I think I've got your point.
yes. So on falsity, that's we say it's just not made out.
Yeah.
If I can move on to the second oral representation, which is the oral multi-layered representation, that's at paragraph 17 of my note.
Yeah.
Your Honour, we deny that this representation was made, and I invite Your Honour to make a finding to that effect. And there's 3 points really that I want to make in support of that. The first is that the representation is fundamentally inconsistent with the nature of trade finance. The representation pleaded is that the fund would use all of the risk mitigation measures referred to in the RFP and the PowerPoint for every transaction. However, as Mr. Ali Ibrahim accepted in his cross-examination, trade finance comes in different forms and each form may require a different type of security. He was already aware of this before he reached out to Ribble. And that's also consistent with the evidence of Mr. Swartz, which is paragraph 5.6 of his statement, which is he says it's not a one-size-fits-all, and that's why we would not have made that representation. It would therefore, in my submission, make no commercial sense for Ribble to tell ALAWWAL that all the risk mitigation measures were applied to each transaction. And we say that that means there's an inherent improbability that such a representation was made orally.
I mean, it seems to me I've got to look quite carefully at what this representation was. I mean, focusing on the words which have been pleaded at the top of page 12.
Yes.
Respect of every transaction undertaken by the fund, so for all transactions, it used the multi-layered risk mitigation measures identified in the RFP and the present, which included, etc. Now, that seems to me to be saying, for every transaction, we've used the approach explained in the RFP and the PowerPoint transaction, which doesn't mean we've taken everything. We've taken every measure for each transaction, but it does mean that we've used the approach and therefore we've used the measures which are appropriate for each transaction. It isn't that a fair reading of what's been pleaded?
With respect to it, I would say it's not,
Right.
and it's
Why
not what
not?
is intended. I think the way Your Honour reads it is one way of reading it, and I think it's the fair way of reading it, and it is possibly how one should read it. The way in which the case is put in respect of the oral representations, including here, is in respect of every transaction undertaken by the fund, it used the multi-layered mitigation measures explained in the RFP. Now, it's not saying it used risk mitigation strategy. It's talking about the specific listed measures.
Yeah.
And if we recall the evidence of Mr. Malaka,
Well, I mean, I do recall that, and
Yes.
I recall the discussion taking place, possibly influenced by me as to whether it's used all the measures in every case or whether it's more than that. But anyway, okay.
well, just on that point, Your Honour, because it is important, because it comes back to my point about what's the parameters of what is pleaded. What we're looking at is a master rep. It's made up of all these million.
No, I understand. What we're looking here is the second layer, or the I mean, you explained it openly, and I've looked at this. We've got individual statements which are said to have been made at one of the 4 meetings.
Yes.
And which are then, as it were, pulled together for the purposes of,
Yes.
of what those taken together or individually meant.
Yes, but looking at the one we've been looking at subparagraph 2, Your Honour, if just to go to the point about whether Your Honour's reading of it is fair, it's a reading with which I could agree with. But the reason I say it doesn't represent what they say is, for example, if we go back to 26.2 at page 10,
Yeah.
this is the actual representation that is said to have
Hang
been
on, let me
made.
just get there.
Sorry, page 10, sub 2 and 3.
Hang on, I want to be clear what this. This is what's said on the 6th of February.
Yes, that's correct, Your Honour. So
Yeah.
two,
Okay.
two and
So
three.
that's
So it's
that's everything for.
yeah.
Okay.
And these are the mini reps that make up that master rep. So they have to be read together, and the representation is that you used all of them. But what I do say is that the notion that alleged representation was made is undermined by the very documents that it seeks to rely on. Because as was, in fairness to my learned friend, as he confirmed during his oral opening submissions, ALAWWAL's case on those documents is that they represented that a risk mitigation strategy would be used, but not necessarily that all of the risk mitigation measures would be applied to every transaction. Now, in respect of the oral representation itself, it's important to look at the evidence, because both Mr. Ali Ibrahim and Mr. Malaka, and Mr. Malaka particularly, who was at the 6th of February meeting, says, well, yes, they said this, but I never understood it to be that. That's not what I took away from it. I thought they would use, it means more than one, and I thought they'd use multi-layered risk mitigation. So we say the documents, as well as the evidence of their witnesses, fundamentally undermines that the oral multi-layered representation was actually made, or that it was actionable if it was made.
Yeah.
And Your Honour, I won't. If I can just.
Well, just before we go on to that,
Yeah.
I need to look at this quite carefully, and I will do so. And I understand the point you're making, if we could just go back to page 12.
Yes, Your Honour.
If the representation, the master representation, which is pleaded in some paragraph 2,
Yes.
and taking your point, that needs to align with what's said in the what you describe as the many representations. If this means that in respect of each transaction, it used the multi-layered strategy and applied such risk mitigation measures as were appropriate, let's just assume that's what it meant,
Yes.
then do you say, or do you accept that that was false, or do you say, no, well, if that's what it means, then the evidence shows that we did apply that. So taking, for example, the sorry, the name's gone from my head. The transactions which are referred to in the 2017 accounts, which had
Farlin and
gone.
Metric.
Yes, sorry. If one looks at the Farlin position,
Yes.
do you say, well, if that's what it means, then those transactions do show that there was appropriate risk mitigation measures?
Quite.
That they may have gone wrong, but
Yes.
but they're in place. If that's what it means, then as it were, we didn't do anything wrong.
Yes, Your Honour. If the representation is that a multi-layered risk mitigation strategy was employed, but it varied depending on the circumstances of the transaction, then we say that's consistent with what our case is.
Right.
Your Honour, I was going to move on to the third oral
Yeah.
representation, which is this oral lower growth representation.
Yeah. Sorry, let me just get that up.
Yes, it's 29.3,
Yeah, I've got it.
still on page 12.
Yeah.
So the fund achieved lower returns than its competitors because it only dealt with reputable clients and insisted on each transaction being protected by guarantees and other risk mitigation measures. Now, we do not admit that this representation was being made, so it's for ALAWWAL to prove. However, what we do say is if it was made, again, it falls under the realm as with most of these oral representations, that it's a generic statement that is effectively sales patter. You know, this is why we're doing what we're doing by reference to everyone else. And we say it's not actionable, and there's 2 points that I make in respect of that. The first is that the alleged representation uses what I would describe as high level and fairly unspecific language. The concept of what constitutes a reputable client, I've already said, is vague and subjective. The competitors referred to are not specified. The other risk mitigation measures are not specified. So it's very generic again in the way in which it's stated. It's somewhat vague, and all of that suggests that if the allegation was made, it's not intended to constitute an actionable representation, but it's just a vague and not objectively verifiable sales talk. The second point on that is that there's no evidence that Mr. Zografos had any knowledge of how the other funds, other than RASMALA, mitigated their risk. And that would have been obvious to ALAWWAL at the time, that Mr. Zografos was a person marketing a Ribble fund. He was not marketing any other funds. So we say any statement by him to this effect cannot have been intended to have been taken seriously. It's, as I said, sales patter. And Your Honour, there's not really been a lot of focus on that particular representation during the course of the trial. So I don't know to what extent that's the focus or the more of the serious representations. But we say it's not one that is an actionable representation. But in any event, in terms of falsity, I'm not sure where they really go on this.
Yeah. Well, look. I mean, I've read what you've got to say, and I think I understand what you're saying about this one.
Yes. Well,
I mean,
it's 66.5.
I'll hear what
Yes.
benefit Mr.
Well,
Adair
it's-
said by way of reply, but one of the things it seems to me, I don't at the moment see how this representation could succeed if others, particularly those below it and so forth, fail. But anyway.
Yes. Well, Your Honour has hit the nail on the head, which is 66.5 of the pleading, page 36. It appears to be that this representation is contingent on all of the other representations being untrue or being false. So
Sorry, which
page
page?
36,
Let me just have a look at that.
subparagraph 5 at the top.
Yeah.
So
Yeah. Okay.
the fourth representation, Your Honour, is the oral 0% risk representation. Now I have addressed you on this at some length at various points. I don't know to what extent Your Honour wants me to go through these points again.
Well,
Beyond.
let me just have a look and see specifically what you've put in relation
Yes.
to this. I just want to see what your reference is to Mr. Al-Abraham about not relying on it. Let me just have a look at that.
Sub C, Your Honour, is that?
Sorry, yes, sub C.
Yes, I thought that was going to be the one point that I would address Your Honour on.
So it's page.
Day 2, page 105. Sorry? 106, sorry, Your Honour.
Yeah, I've highlighted it.
Yes.
See if I've highlighted the right bit.
Yes. No, sorry, it is 105. It's 14 all the way down to 22. But the evidence obviously carries on into 106. So the 0% risk is always.
Sorry, let me just. Sorry, I'm just
Sorry.
reading this through. Sorry.
If you want to start at line 15 on page 105.
Just give me a. Yeah, okay, I've read it.
Yes.
Yeah, okay, well, I've read it. Sorry, if you wanted to make any other points in addition to it, but I've read what you're.
No, Your Honour, I think you have my points on that. That was one of the only points I did want to flag up.
Yeah, okay.
And the fifth representation, therefore, at paragraph 20 is the oral suitability representation.
Yeah.
And we deny that representation was made, and we ask Your Honour to find that it wasn't.
Sorry, just again, just.
Yes, 29.5.
No, sorry, I'm just wanting to be on each of these. I just want to make sure I've got the. Yeah, okay.
Yes.
And sorry, can we just look at 66 in the context of why that is untrue? So
Yes.
where's the pleaded cases to falsity on this?
I don't think there's a specific pleaded case on falsity on that.
I think it's
I thi-
26.2.
Sorry, Mr. Adair.
26.2, Your Honour.
26.2, thanks.
That's not falsity.
Well,
Is Your Honour looking
Oh,
for the
sorry.
falsity?
I was looking to see if there was a specific pleading of falsity in
Yeah.
relation.
Oh, sorry, apologies.
That would be at paragraph 66. I don't believe this is specific. There's no. I think the way my learned friends dealt with it is that to say sub 5 is caught up in what is the oral risk representations, and
Yeah.
then there's general statement. There's general pleadings as to why that is false.
And sorry, and where's that pleading?
It's paragraph 66, starting at page 35. Your Honour. That's the paragraph. that deals
Can I
with
just look
falsity.
at that?
Yes. So it's not. There's nothing said there at all, from what I can see.
The effect of 5 is that the claimant says that it made plain to the Ribble that it wanted a low risk investment. So what this means is that the fund was suitable, therefore it was low risk in broad terms. And Mr. Adair would say, well, this wasn't low risk. Well, for a number of different reasons. That's how he put his case in relation to that.
Yes.
And
Well, you know, just on that, whilst your honest train of thought is on that, it's important to pinpoint where that representation is made, because that's important. And they say that representation was made on the 14th of November, the very first meeting by Mr. Zographos.
yeah.
Now, Mr. Malika refers in his evidence to having explained ALAWWAL's alleged investment objective, but he doesn't say a representation to that effect was made. So the representation about suitability is the very first introductory meeting. And my submission on that is the factual premise that ALAWWAL are saying is there is twofold. One is we wanted Sharia-compliant trade financing. That's I don't think there's any issue with that. The second is low-risk profile. And what I say is, well, it's the point I made yesterday, Your Honour, which is what is a low-risk profile to one person is not a low-risk profile to another person. So what does that actually mean? What did it mean to ALAWWAL? What would it have meant insofar as it was explained to Mr. Zographos that allowed him, if he made the representation, to say it was suitable? But what we say is that the evidence demonstrates that that factual premise is not actually there to begin with. It demonstrates that ALAWWAL's investment objectives were not, as it alleges, limited to low-risk investments. They were prepared to look at low and medium investments in respect of their US-denominated fund. And Mr. Ali Ibrahim confirmed in his oral evidence that ALAWWAL's risk strategy and their appetite was generally considered to be low and medium risk investments. And the documents that exist, Your Honour, we say support that. because the documents all expressed its investment objectives as including medium risk investments in 3 different ways. You have the internal BDC minutes that record what happened at meetings before they meet Ribble. You have the corporate account form that they actually submit to Ribble for the purposes of opening the account. And you have its own investor-facing documents, the terms and conditions of the ALAWWAL USD fund, each of which, again, say the risk appetite is low and medium risk investments. Now, there was an attempt by Mr. Ali Ibrahim to say, well, I meant low to medium, but there's a medium, and there's a high medium. We say that's just nonsense because it's not reflected in any of the evidence. He says it's industry standard, this is what is meant. I don't accept that that's right. And my submission, that was just Mr. Ali Ibrahim trying to explain away what is an obvious issue on the documents, which is ALAWWAL was internally, formally to Ribble in the account opening form and to the world, its potential investors, that we take low and medium risk investments, whilst at the same time saying they came and explained what their investment objectives were and said it was only a low risk profile. Now, we say, given that factual premise that exists, it's implausible that ALAWWAL would have explained to Ribble that's what its objectives were, or that Mr. Zografos would have made a representation that the investment was suitable for their investment objectives. So we say, in light of the evidence, that the factual premise for the alleged representation falls away, and it's inherently improbable the alleged representation was made. However, even if it was made, Your Honour, we say that would constitute a statement of opinion. And that's a proposition that was put to my learned friend in opening by Your Honour. And what I say is that if one party is necessarily saying to another, okay, this is suitable for you based on what you have told me, that generally involves what we would say is a value judgment, which can be subjectively considered a statement of valid assertion without having any certainty that it's necessarily an assertion of the truth, i.e. a statement of opinion. So it follows in my submission that even if that was made, it's at best a statement of opinion. Now, one of the criticisms that my learned friend makes of our case on this is they say, well, you haven't challenged Mr. Ali Ibrahim and Mr. Malaika that they did explain those statements were made, and he cites the Brown and Dunn rule on that. Now, we say that that's wrong for a few reasons. The first thing is Brown and Dunn rule has moved on considerably. Your Honour may be familiar with the Toohey and Griffiths case in the Supreme Court. This one is a bit close to me because what they were considering is the reformulation of the rule as stated in Phipson, and I am the author of that chapter in Phipson. So they were considering the restatement of the rule, and they accepted the reformulation, which is that it's not an inflexible rule. It's not a hard and fast rule. You have to now put every single point to challenge. What it is about fairness to the witness, having an opportunity to put evidence on the point that they want to. But in any event, I would say, Your Honour, that I did put questions challenging the premise that was ALAWWAL's objective to Mr. Ali Ibrahim throughout cross-examination. And I would say that whilst my learned right is fair to say, I did not go to him and say, you did not tell Ribble these were your objectives, were you? It was the last question that I put to him, that was what our case was, and he had an opportunity to reply to it. Your Honour, I can take you to it. It's at
D. Don't worry.
It's at D2, page 111. Yes.
I'll remind myself.
Yes.
If I need to.
If you need to, yes. Well, in respect of Mr. Malika, just dealing with it briefly, that my learned friend says there's 2 points on which I didn't challenge him. The first is that he explained the investment objectives of ALAWWAL. So my learned friend is right. I didn't say to him, you didn't tell Ribble your investment objectives. But he doesn't make he doesn't say a representation is made to him at that meeting that the investment is suitable for his
Yeah.
objectives.
Yeah. Okay.
Um,
I mean, I understand why you've introduced this at this point, and you know, but on this particular point, let's assume against you
yes.
that Ribble were well aware of what ALAWWAL's investment objectives were. Now, there's a factual question as to what they were, as to whether they were low or low to medium, but for these purposes, it doesn't matter.
Yes.
What we're looking at here is the representation that the fund was suitable for those objectives. That's what we're focusing on
Yes.
at the moment.
Yes. And a representation made only at the first meeting. That's when it's said to have been made.
Well, it's subject to the point that these are said to be the result of all four, and I think if necessary will be continuing. But I mean, I agree that
Yes.
that what you're saying is if you go back and look at the mini representations,
Yes.
this is a 14th November
Yes.
representation.
Yes, it might be a false labelling of calling them mini reps. I'm the one who called them that.
Well,
but
I
they're
mean,
the
a
actual.
better case might be the foundation representative.
Yes, exactly. You're absolutely right.
Okay. All right. Well, look. Sorry, I interrupted you. But,
No.
But I mean, I certainly understand your case in relation to the suitability.
Yes,
Suitability thing.
I'm grateful, Your Honour. So that I'll move on then to the sixth representation, which is the oral adequate coverage representation.
Yeah.
That's what we've called it, and it's paragraph 21. Again, we do deny that this representation was made. However, if one just looks at it, and Your Honour may want to remind himself at 29.6.
Yeah, I've just looked at it. I'm sorry, I've literally just been looking at it. Yeah.
Yes. Again, if we say if this representation had been made, it's a highly generic statement that's somewhat vague, and it constitutes either sales talk or an opinion, and therefore not actionable. That one just looks at the words adequate coverage. Those are very much vague and subjective terms. What constitutes adequate coverage to one person might not be an adequate coverage to another person. So it's not something, in my opinion, that is an objectively verifiable statement. And as regards this representation, there is no suggestion that anyone from Ribble gave any examples of the risk mitigation measures which meant the fund's risk was adequately covered at all stages of the transaction, whatever that is, intended to mean. And moreover, if Your Honour was persuaded that the representation was made and that it was actionable, we say there's no basis for finding that it was false. And to illustrate this, I think it is necessary to look at the pleaded case on this at 66.1 of the amended particulars at page 35. So
You'd say there's a break in the chain of the reasoning there.
well, there is a break in the chain of reasoning. Your Honour's absolutely right. But there's, in any event, it's been grouped together. But what it appears to be is the only basis on which ALAWWAL pleads the alleged representation is untrue is that the fund has suffered losses resulting in the suspension of trading. However, the fact that the fund has suffered loss does not mean the fund's risk was not adequately covered, whatever that means. It's inherent, we would say, in the nature of trade finance that losses will be suffered from time to time.
Well, I mean, possibly, but also the gap I was referring to was that if this is a statement of opinion, then it comes back to honesty or reasonable grounds. And
Yes.
where's that link? That was what I meant by the gap in the chain
Yes.
of reasoning.
No, well, Your Honour's quite right. That was the point I was coming to, but I think Your Honour has the point on that. So we say again that there's going to be real difficulties for ALAWWAL, and we say that's just not a representation that they could prove was false, even if it was made. And Your Honour, that brings me on to the final oral representation, which is the oral default representation.
Yep.
And there's been a lot of back and forth on this. We deny the representation was made, and that's the finding I invite Your Honour to make. Now, this is at paragraph 22 of my speaking notes. Your Honour, it's not in dispute between the parties that the 2017 accounts were sent. And as I said yesterday, that the accounts confirmed that there had been defaults in the fund in relation to transactions with Mettrade and filing. There's a number of what I would say side issues about what does it say, how it should have said it, was it correct to, but I say that's not relevant. What isn't in dispute is that the accounts were provided and that they do refer to defaults in respect of those two transactions. And what I also say is that it's implausible that Ribble would have made any representations to ALAWWAL that there had been no defaults, either at the 6th of February meeting or the later 25th of February meeting. And there's 4 points I just want to focus on in support of that. The first is that the representatives of Ribble who attended the meetings and who are alleged to have made the representations were all experienced financial professionals. And that's the most evident on the 6th of February meeting. Mr. Swats he was the senior executive officer of Ribble. And Mr. Bitcon, those are the two alleged to have made the representations, was the head of credit strategies. And Mr. Zografos, in respect of the 25th of February meeting, he was the head of sales for institutional business. And we say that when one looks at the experience of those individuals, it's inherently implausible that seasoned professionals like these would have made a representation to ALAWWAL, which was directly contradicted by financial statements that had been sent to them prior to each of those meetings, which was a document that under the offering memorandum, they would have known ALAWWAL could rely on. The second point that I make is that is compounded by the fact that there was no discussion between Ribble and ALAWWAL about these accounts ahead of the meetings, and Ribble therefore did not know whether ALAWWAL had reviewed the 2017 accounts prior to those meetings or not. So what we say is that if a representation had been made by Ribble that there were no defaults, without them knowing whether ALAWWAL had read those documents or not, Ribble and these experienced professionals would have been taken an enormous risk by making a representation which could easily be falsified by ALAWWAL. And it would have been extremely damaging to Ribble's credibility if it had made such representations and ALAWWAL had falsified it. It would have risked a major institutional investor walking out of the door, because what it would show is that the investment manager did not know what was going on with the investments. And I asked Mr. Malika about the importance of credibility, particularly for senior executives, and he agreed that is something that is important. The third point I make in relation to this is on the 6th of February meeting that was attended by no fewer than 6 representatives of Ribble. And in my submission, it's inconceivable that if that representation had been made, that not one of them would have corrected it, given the risk that I just explained as part of my second submission. And the fourth point, Your Honour, and I'm going to take you to the documents on this, but the fourth point is that Mr. Ali Ibrahim confirmed in his oral evidence, contrary to what he said in his witness statement, that he had read at least some of the notes to the 2017 accounts, and note 9 specifically. And I've given the reference for that in my outline submissions. Your Honour, if I can just take a look at note 9.
Well, just before, I by all means, we'll go to the just before we get there.
Yes.
Now, this representation has as its foundational representation as 26, 1, 4 and 8, which start on page 9. Now, I've only just noticed that there are two 26 ones. I'm sure that's been pointed out to me before, but it's the first 26 1 on page 9, not the second one on
Yes.
page 10.
Yes.
26 1 is no legal issues or defaults.
Yes.
26 4 is there were only a few scattered cases of default involving small companies, all settled satisfactorily. And 26.8 is due to the strict investment fund, there were no recorded defaults in the fund. There have been delays to be paid in the end to awardsmen to the guarantees. And then, sorry, there's one other as well, which I've just, oh yes, and then the final one is 27.4 on page 11. There have been no defaults in the funds. In the case of delayed payments, the fund had the right and capability to enforce some or all of its guarantees. Now, those are all the ones which together are said to make the 30 no defaults in the fund and no legal action have been taken. So that's what's been put together.
Your Honour may be right.
Well, I think I am, because 30 says the 6th February pleaded at 26.1, 26.4 and 26.8 and the 20 constituted an oral representation. So they've
Yes.
expressly, I think they've expressly,
Yes.
that, in this
Yeah.
case, they've said these are the foundation stones and this is the bridge which sits on top of the foundation.
Yes.
Now, so that's how the pleading works, so far as that's concerned. Now, read fairly, it seems to me that those together are saying something to the effect of there's been no material defaults. That's one point. The second point, just to, or possibly, yeah, well, that's the first point I'd invite you to comment on. The second is that, which is a rather different sort of point. Both Mr. Al-Ibrahim, sorry, start again. Both Mr. Bitcoin, actually particularly Mr. Bitcoin, and to a lesser extent, his boss, were emphasising the difference between default on the one hand and late payment on the other. Now, the reason I ask you about that is that it seems to me that one possible finding in relation to this is that what had been said, broadly speaking, is that there were no material defaults. Any minor scattered ones were inconsequential. And that's likely to have been true if you look at the evidence taken as a whole. And it's likely to have been said because of the way in which your witnesses dealt with the matter in cross-examination of their evidence. So what do you say about that? What do you say about those 2 points?
Well, so Your Honour, if I've understood, I just want to make sure I've understood. The first point is that reading those together, is it saying that there are no material defaults? That's the first point.
Yes, I mean,
Yes.
I haven't put precise words, but
Sure.
you have to read. Well, on the wording of paragraph 30, you have to read paragraph 30 subject to the previous ones, and a fair reading of that means that you have to read no defaults in the context of what we said before. That's the way I put it.
Well, Your Honour, what I would do is just taking a step back, looking at paragraph 30, I would say read it for what the words are. The words are not no material defaults, it's no defaults. So the representation that is being made is not that you didn't tell us there were material defaults in the fund, you just told us there were no defaults. So I think introducing the material element to it, it does not reflect what is actually the pleading. case, which is that you told us there were none. And just so I'm clear on Your Honour's second point, I think what Your Honour was saying is that my witnesses made a distinction between, well, what is a default and what is a past due, I think, as they put it.
Yes, those are the words they use.
Yes.
And just on that,
yes.
One reading of their evidence is that they were very focused on distinguishing between those two concepts in a way which might have led someone who was listening to them to hear them saying there have been no defaults and being very insistent about that, even though there had been what they described as being past dues. I mean, that's
yes,
the commentary.
Yes, and I think Mr. Swart's more so on that than Mr. Bitcon, who I think was prepared to accept when he was taken through the cross-examination.
Well, I need to look at their evidence.
It's a default,
I think
of course.
They both said different things about this.
Yes. Both witnesses do make a distinction on that, Your Honour. But what again, looking at what is said, or looking at what they were asking about, is have you got clients of the fund who have not paid on time? On ALAWWAL's case of default, that's what they classified as got. There's a legal obligation, and have you failed to meet it? Now, in my submission, the fact that the accounts are sent, and I'll come to that in a minute, and that they do record that there are defaults and litigation in respect of Metrate, in my submission, it would be implausible that that is not brought up by Ribble if they are asked, in whichever way they're asked, tell us about defaults or legal action, because it's both. It's not just one, it's both. As well as late payments, or however it may have been phrased. Specifically in respect to the Metrate transaction, it would seem odd in my submission that if the question was raised about default, however it was raised, and legal action together, that Metrate is not one of the things that would have been brought up, given it was in the document that was sent to ALAWWAL. So that's what I would say in respect of that.
Right.
And Your Honour, if we can well, just before I get to the note itself, Your Honour, I have given the reference at sub D at page 13 of my outline submissions, where Mr. Ali Ibrahim said he had read note 9. I don't know if you want me to take you to that.
No, and actually, sorry, I'm not going to stop you. Take me to anything you want, but actually, I did look yesterday specifically at Mr. Ali Ibrahim's evidence in relation to this, because I wanted to remind myself as to how that was put forward. So I have looked at that, but say anything you want to about it.
No, I will, Your Honour, but is this, I've been going on, is this a convenient moment for the break?
Yeah, well, yes, it is. I mean, I suppose the question is, how much on this point have you got on the 2017 account?
Maybe another less than 5 minutes, Your Honour, so I'm happy to finish
well,
the point.
I wonder whether the sensible thing in that case, if it's less than 5 minutes, is to deal with this point, and then that then goes on to written representations.
I'm grateful, Your Honour. If we can please go to F2856.
Yeah.
So this is one of the notes that Mr. Ali Ibrahim accepts he did read. And we can see this is specifically about the Muhabara facilities. And if one looks at note 9 in its entirety, we see that there is in fact an entry for past due but not impaired of $14.3 million.
Yeah.
And then below it is the commentary, the past due but not impaired Muhabara is for the past 178 days. So even if he didn't read note 31B, which I don't accept, a man of his seniority and professionalism would not have done, but even if we accept that premise, he says he read this note. And what is clear in this note is that there is a past due that has been past due for at least 178 days, and it's for $14.3 million.
Yeah.
Now, much is made about the fact of, oh, well, actually, if you look at the true picture in September, it was $35 million. Again, I say that's irrelevant. I also say the figure is false, because one has to look at, you have $35 million of exposure, but you have, I think, $27 million of insurance coverage. You then have other mitigants in place that may do that. So it's not true to say you have 35. That's possibly the gross position. The net position's a lot less. But what we have in these accounts is 14.3 million past due, 6 months, and Mr. Ali Ibrahim says he read that. Now, if we accept his evidence, then however you want to label it, it's clear he is aware that there is a contract that has not been paid for 6 months, and that contract is for $14.3 million. And one then goes to note 3.1b at page 49 to understand exactly what that is about. So we say if he read that note as he says he did, that has very much alerted him to the fact that there is a default. And that's why we say it's just not probable that anyone from Ribble, including its senior executives, would have made such a representation, knowing that ALAWWAL had these accounts. Now, the next point I want to go on to briefly, Your Honour, is that even putting aside Mr. Ali Ibrahim's evidence or Mr. Malaika's evidence, the ALAWWAL risk team did review these accounts, and that's confirmed in their internal assessment report. If we can just take a look at that at F185MT. We're starting off at page 2. Sorry, 3. No, we can start at page 2, Your Honour. We can see the first point that's noted there is they're noting about there's no provision for credit losses for the fiscal year 31st December 2017 that can negatively affect the profitability of the fund, and then on the next page, page 3, we see again, upon reviewing the fund's financial statements, we noticed that there were no material reservations from the external auditor in his report on the fund as of the 31st of December 2017. And what this document shows, which is an internal risk assessment document done by the risk manager and the director of governance and risk management, is again, it shows their risk team did review these financial statements. And that was the basis on which they made their recommendation that an investment be undertaken into the fund. And we can see it's dated 25th of March 2019, which is before the first investment is made. So there is at least the risk team, there is a document that says they did review the fund's financial statements, but you now have Mr. Ali Ibrahim's evidence that he also read the note. So we say if this no default, no legal action representation had been made, it's just inconceivable that ALAWWAL would not have queried the inconsistency between the 2017 accounts and what was said or allegedly said at these meetings. But there's just no email doing so, and we say the reason it didn't do so is because the representation was not made orally, and there was no inconsistency between what ALAWWAL had read in the accounts. And given this representation, if I can just wrap it up, Your Honour, before the break, this representation, if one stands back, is really just an odd one, because such significance is placed on it. This is an important representation, what you said to us, that induced us into making this investment. It's, in my submission, somewhat implausible, but also inconceivable, that there isn't even so much as a follow-up as an email saying, we've been doing our due diligence, you've said there's no defaults in this fund, can you just confirm that to us? And I say that lends support to the fact that the questions were never asked and no representations were ever made. The information was in the financial statements, and they read that. So, Your Honour, that concludes my submissions on the oral representations. Is this a convenient moment?
Yes, it is. We'll adjourn for 10 minutes until
22,
Yes.
22.
Thank you.
All rise.
Yes.
Thank you, Your Honour. Your Honour, I'm going to try and get through my next topic on the representations,
Yeah.
hopefully more quickly, because there's
Yeah.
considerable overlap on the points. Your Honour, I do make some overarching points, which are set out at paragraph 23 of my outline submissions. And
Yeah.
one must remember all the written representations are said to have been made in the RFP or the PowerPoint. Now, Your Honour, the overarching points I make are at 23 sub 2, sub 3 and sub 4.
Yeah.
I'm not going to go through all of them because Your Honour will have seen them, but effectively we say Mr. Ali Ibrahim's evidence was illuminating on this in the sense of he understood these are common practice marketing documents that are sent out
Yeah.
as sales pitches, and the offering memorandum is the important document. And we say those concessions he made map directly onto the actual dealings with Ribble and ALAWWAL here. The presentation was the very first thing that was sent to them
Yeah.
before the meeting even happened. And that we say providing both of those documents, they're generic marketing information that's providing information. It was clear that what ALAWWAL had to do is rely on the offering memorandum. And we say that's underscored, and that understanding is underscored by marketing documents sent out by a number of other firms, and I've given the references to that at sub-paragraph 5 on page 14. So with that, Your Honour, I'm going to jump straight into the individual representations, and I think I can take most of these fairly quickly.
Yeah.
The first one is the written client representation, and Your Honour, that mirrors what is the oral client representation.
Yeah.
So I rely on the same arguments as to why we say that's not actionable.
Yeah.
And unless Your Honour wants me to address them on anything else on that, I'll move on. The second written representation, which again I think I can deal with quickly, but I'll just take a second on it, is the written multi-layered representation. Now, as I mentioned earlier, as I understand it, ALAWWAL's case on this is that the written representation is different to the oral one. The oral one is all is applied to everything. The written one is that the fund applied a multi-layered risk mitigation strategy for each transaction, rather than applying all risk mitigation measures for each and every transaction. My learned friend said that in his opening, and that's how Mr. Ali Ibrahim says he interpreted both of those documents. But what I say is that if that is how ALAWWAL puts its case, then we say the alleged representation fails, because insofar as the court considers it was actionable, my case is it was true. And there are 2 points that I make in respect of that. The first is the falsity point, which we've looked at, Your Honour, which is it's said that it's false because ALAWWAL, sorry, not ALAWWAL, the fund incurred losses that resulted in the suspension of trading of the fund. But again, if the fund incurs losses, that does not mean the fund did not apply risk mitigation strategy. That conflates the question in my submission of whether fund implemented a risk mitigation strategy at all with questions of whether the fund's risk mitigation strategy was successful. And the second point I wish to make is one, when one looks at the examples of the trade finance transactions that the fund did invest in my submission, it's clear the fund did adopt a risk mitigation strategy, which involved the application of different risk mitigation measures. I don't propose to take Your Honour through all of them, but 25 sub 3 B and C, Your Honour, what I've done is focused on the documents that are in the bundles and in respect of the 2 transactions that are identified.
Yeah, I mean, this is really
There.
following on from the point that you and I discussed earlier in the
Yes.
context of falsity, that insofar as you look at the documents, then they see risk mitigation strategies being put forward.
Correct.
These are just the documents.
These are the
for
documents
these
that support.
particular transactions support that point.
Exactly, and Your Honour can see there's at least 4, I think, on each of them, and we say that supports, well, there was a risk mitigation strategy, and we did employ it. So I don't, unless I can assist Your Honour further on that representation, I'll move on to the written currency representation.
Yeah.
And again, on that, Your Honour, I don't take issue with it. Our transactions were done in US dollars. So insofar as they say the statement was made, it's a true one.
Yeah.
But I don't think much is actually made of that.
Yeah.
We then get into the fourth written representation, which is the written third-party representations. And, Your Honour, I can deal with this briefly because I think, given what ALAWWAL's case is on the written multi-layered representation, as I understand it, its case on the written third-party representation must also be that it was represented by the fund, that they appointed third-party inspection companies and collateral management companies as part of its risk mitigation strategy, as opposed to on each individual transaction. And that reflects how Mr. Ali Ibrahim said during cross-examination he understood the RFP. And I have given the reference there for Your Honour at 27 subparagraph 2. Now, insofar as Your Honour considers this alleged representation was actionable, we say there's no basis for concluding that the representation was false. ALAWWAL has not identified, either in its pleadings or in the evidence, any basis, none whatsoever, for concluding that the fund's risk mitigation strategy did not include appointing third-party inspection companies and collateral management companies where the circumstances of the transaction required it. So we say even if Your Honour was to conclude that this written representation was made, it's not one that goes anywhere. The fifth written representation, Your Honour, is the written low-risk representation. And Your Honour will find that in paragraphs 36.5 of the amended particulars of claim, page 21.
Yeah.
And Your Honour, what I say, what my submission is on this, is that the representation was not made in either of the documents on their true construction, and even if it had been made, my submission is it's not an actionable written representation, and I invite Your Honour to make a finding to that effect. Now, as I understand from my learned friend's oral opening, the relevant statement relied upon by ALAWWAL is page 6 of the RFP, and again, he took you to it again during closing. If we can take a look at that at F118, page 7. I think it's under differentiating characteristics.
Sorry, just give me a second to get
Sorry, F118, page 7.
Yeah.
And I think my friend relies on the second bullet point on dating ticks, which is the fund focuses on capital preservation and uses risk mitigation factors, including over-collateralization and credit insurance, in order to reduce volatility and maximize returns within the strategy's conservative risk profile, making it an attractive alternative to other assets class. And in my submission, that does not constitute an actionable representation that the fund was low risk. I think my learned friend focuses on the words conservative, the strategy's conservative risk profile. And the wording conservative risk profile in my submission is relative. It really does beg the question of what investments the fund is being compared to when it is described as conservative. The fund obviously isn't as low risk as money market rates, LIBOR 3-month, but equally it may not be high as risk stocks and shares. But what the statement does not say is that the fund is a low risk investment in absolute terms.
Yeah.
And second, it wouldn't be possible to represent that an investment in the fund was low risk in absolute terms for all investors, because as I go back to the point, what is low risk for one is not low risk for other. So that can't be read in my submission as a statement that the fund was a low risk for all investors. Instead, it's again just a generic marketing material, including it in a non-specific marketing document, which was not intended to be relied upon and was not specific to the needs and investment objectives of any given investor. The other thing, Your Honour, just to flag it up to you, because I think you raised this yesterday and I mentioned it was in the PowerPoint, you can see the last sentence above differentiating characteristics refers to LIBOR plus 5%.
Sorry, just I've just turned on to the where now.
118 page 7.
118 page 7.
Yes.
So we're just.
So above differentiating characteristics title, Your Honour will see reference to.
Let me just flag that because I actually.
And Your Honour, if I can just also.
Sorry, just give me a second.
Sorry.
Yeah, okay.
And Your Honour, just whilst we're here, F2035, I don't propose to turn this up, but that's the reference in the PowerPoint where LIBOR plus 5% is set.
Yeah.
Your Honour, those are my submissions on the individual written representations.
Yeah.
Unless I can assist Your Honour further on those points, I'll move on to reliance, which is my next topic.
Yeah.
Which starts at page 29. Now, Your Honour, there are two requirements as to reliance that ALAWWAL must satisfy, and I don't think it's in dispute. The first is it must prove that it actually relied on the alleged statements in deciding to invest, and the second is it must prove that its reliance on the alleged representations was reasonable, and that's Articles 20C and D of the Law of Obligations.
Yeah.
And we say on the evidence that is before this court, ALAWWAL has failed to establish either requirement. Now, there's four categories, Your Honour, that I want to deal in respect of this. There's the sophistication point, which is important. There's actual reliance, there's reasonable reliance, and then there's the disclaimers, which falls into the above categories, but I'll deal with separately. Now, in terms of ALAWWAL's sophistication, I deal with that first because we say it's a crucial part of the context in which the question of reliance arises. And we say the evidence that has emerged during the course of this trial only reinforces that ALAWWAL was a highly sophisticated institutional investor who did and could reasonably be expected to rely on its own internal due diligence and assessment of the merits of investing in this fund. Now, Your Honour, I've set out at paragraph 31 a number of points that came out in the oral evidence, which I say support ALAWWAL's high sophistication.
I mean, I think you're kicking it an open door here in the sense that it's accepted that they're sophisticated. Yeah, I mean, I'm not going to stop you, but I mean, I think you are kicking it an open door.
Yes, well, all I was going to say, Your Honour, is I have set out at paragraph 31 all the points I rely on that kind of reinforce just how this is not a client who's just a professional client. It's a highly sophisticated institution, one that's very familiar with what's happening in respect of funds, how they operate, how they're structured, what they can rely on, and that's what I set out there. So I won't read them out. And the expertise, we say particularly here, in those examples of the personnel is important, i.e. Mr. Al-Ibrahim, because he's the one who's basically managing this and is the one who has said, this is what I looked at and this is what I understood. So if I can move on to actual reliance, in my submission, ALAWWAL cannot establish actual reliance for two reasons, and this is paragraph 32 of my outline submission.
The first of these looks to me to be pretty bold.
Yes.
I mean, they weren't committed, I mean, it seems to me they weren't legally committed. Settled decision to invest can't possibly mean, despite what's positively being said, there are things, important things, which are going to happen thereafter, due diligence and so forth. I mean, well, yeah.
Well, I take Your Honour's point, and it's not a point I'll lay, but I will move on to my second of the reasons. But what I will say in respect of that, Your Honour, is that that's the pleaded case, and I accept Your Honour's point, which is that well, you know, everything's going to happen later on, and there's going to be due diligence that's going to be carried out. But the way it is said in the reply is that there was a settled position to invest in the fund, and that's what the 2nd of January email
Well, just to
represents.
be complete, sorry, I think it's important. It says subject to due diligence if you go to the actual pleading to which my learned friend refers.
Yes, but if one reads it, a settled decision to invest is, I have made the decision to invest in your fund. I'm now going to carry out the due diligence, but your decision to invest has still been taken. But putting that to one side, Your Honour, in any event, if you're not with me on that point, in my submission, the evidence shows that the decision to invest in the fund was based on ALAWWAL's own quantitative assessment of the fund's returns and their standard deviation. And I say that that's demonstrated by a few documents, which I think is worth looking at. The first one is the BDC. Sorry, actually, if we can start off on the BDC minutes on the 24th of February. That's F173MT.
Sorry, what's the reference again?
It's
yes,
F173MT.
Yeah.
So it's bullet point 3. So this is the decision where they agree to begin the investment. The performance of the trading funds was reviewed and their returns compared to the risk rate achieved over the past years. The head of the stock markets unit recommended that investment in the lower risk funds be initiated, provided that investments in other trading funds are diversified after the completion of the full calendar year. The committee approved and agreed to beginning investing in the RASMALA and AGC funds as they are the lowest risk funds. Now, Your Honour, this minutes of the meeting, we know from an internal document produced by ALAWWAL, which is the 23rd of January document, that this is effectively, it flows from that. So if we can look at that minutes document, and I use that in inverted commas, it's at F140. And it's the point 2 in the table on the first page. And this is what is said, I think it's being said, this is what explored with Mr. Zogafos. Risk rates for each fund, standard deviation during the past years were reviewed and compared to the investment returns. And the risk rate is being used to refer to the standard deviation. And if we look at page 4 of this document, this is the table that was produced by ALAWWAL, and what they're doing here is comparing 5 trade funds that they were looking at, and Your Honour will see AGC and RASMALA have among the lowest standard deviations in their monthly historic returns. That's the little table in the right-hand corner. I think both are at AGC is at 0.05% standard deviation, and RASMALA is at 0.11. So if one then goes back to the minutes at 173MT, it maybe Your Honour doesn't need to go back to the document, but if one looks at what is said there, what that confirms in my submission is that ALAWWAL was investing in the RASMALA fund as well as the A fund because it considered them to be the lowest risk based on their standard deviation as compared to the other funds that they were looking at.
Yeah.
There's no reference in this meeting to any of the alleged representations. Instead, the investment in the fund is based on what I say is a quantitative analysis that ALAWWAL has undertaken themselves. these are 5 funds I've identified. What I'm looking for is the one that gives me the lowest standard deviation, and that's the one that I'm going to invest in. And that analysis of the basis for ALAWWAL's investment, in my submission, is amply supported by the evidence of Mr. ALAWWAL. And, Your Honour, I've given a number of references.
The two propositions aren't inconsistent, are they? That these were the lowest of the funds we're looking at here, and separately we were told that they were low risk. I mean, they're not mutually exclusive, are they?
Yes, but in this context, Your Honour, what I would say on that is, I don't know if inconsistent is the right word, but they don't fit together. Even if they were told, and I don't accept they were, but let's assume they were told that the fund and the other funds were low risk. What I'm saying is that their basis for investing, the information that they relied upon, was not the statement that the fund was low risk, but their own quantitative analysis that AGC and RASMALA were the lowest risks of the funds they were looking at. So it's possible they were looking at 5 high-risk investments, and the 2 they decided to invest in were the lowest risk funds on their analysis based on standard deviation out of those 5. So whilst Your Honour is right that they're not necessarily inconsistent, you can have the lower risk of these funds is not necessarily inconsistent with it being a low-risk fund. What I'm saying is their analysis and their reason for entering into the transaction was that the 2 funds they chose represented the lower risk of the 5 they were looking at. It doesn't mean those 5 were low-risk funds. It's just their analysis of the standard deviation, which is really to do, I think, with volatility, is that AGC and RASMALA come out at the lower end of that. And that's actually the driving force behind, we say, the investment decision. Not any of these alleged representations, but their own analysis undertaken that's shown in this table, which is then referred to at the BDC minutes, the BDC meeting on the 24th. And it may be worth just looking at some of the evidence, the oral evidence on this, Your Honour, before I move on. If we can go to Mr. Ali Ibrahim's evidence in day 2, page 82. So, Your Honour, it's really lines 6 to 14. Now this is what I would call a speech. It's something that Mr. Ali Ibrahim just came out with. He wasn't being asked it. But if I can invite Your Honour to read 6 to 14. And we say that shows that it's him and ALAWWAL classifying the fund as what it is based on that analysis of the volatility. And if we look at the next references, page 113 in the same transcript. And it's page 113 of the transcript. I'm specifically looking at lines 12 to 16, Your Honour, which again, is just a statement that he came out with. He volunteered this more than it was relevant to the question being asked.
Yeah.
So he's saying how he differentiates between it is his own analysis of the volatility, which is what is the standard deviation. And Your Honour, I've given the reference in my notes. I won't go to it because it's a longer piece of it. But at day 3, page 66 to 68, again, Mr. Ali Ibrahim and I had an exchange where he says, he accepts the approval was based on the fact that it's, RASMALA and AGC were the lowest risk among the funds in terms of volatility. Now, just to be fair to him, he says that that's not the only reason for the investment, but he accepts it's not. No other reason is stated in the minutes. So in my submission, the evidence demonstrates that ALAWWAL was relying on its own internal quantitative assessment when deciding whether or not to invest in the fund. It was not relying on the representations, and that's why when you look at all of the key documents which have any form of reference to a recommendation to invest or an agreement to invest or an approval to invest, so we see the minutes on the 24th and we see the risk assessment form. There's no reference to any representations in there. It's standard deviation quantitative analysis in the minutes, and in the risk assessment forms it's the offering memorandum, the DDQ and the financial statements.
Yeah.
And that really does explain a number of things in my submission. It explains, for example, why ALAWWAL never queried any inconsistencies between the offering memorandum and the alleged representations that are made. We say no queries were raised and there's no documents following up anything because their decision to invest was not based on representations. It was based on their own analysis, quantitative assessment of the returns and their standard deviation. And we also say that explains why ALAWWAL decided to invest in the fund, notwithstanding its cases that it only wanted low-risk fund investment, but the risk manager and director of governance and risk management at their own firm concluded that the investment was not a low risk, it was a moderate risk. My submission is no one, Mr. Ali Ibrahim, Mr. Malaika, no one at ALAWWAL paid any attention because their analysis was a quantitative assessment done by their own research and their own diligence. So Your Honour, moving on to my third category now, which is reasonable reliance. What I say is that even if ALAWWAL could establish actual reliance, which we say they can't, but if they could, in my submission, they cannot establish that it reasonably relied on the alleged representations in deciding to invest in the fund. And this is paragraph 33 of my submissions. There's 2 points I want to make in respect of that. The first is that in respect of the oral representations, we say there is no basis for concluding that ALAWWAL could have reasonably relied upon the representations. Now, in that regard, we respectfully agree with what was Your Honour's observations expressed right at the start of the trial during my learned friend's oral opening.
For the avoidance of any possible doubt, and as with any other comments from myself, those
Yes.
are not conclusions
Of
or
course.
anything of that nature.
They're not conclusions, Your Honour. What they are was a way for Your Honour to test the case that my learned friend was putting to you. But in my submission, what I would say is Your Honour's questions were right in the way in which it tested that. And that is, which is, in terms of the oral cases, people, they do get carried away with themselves and they may say stuff that's over the top. There's not really an intention that it's relied upon in that way. And it's the same, if they, it's at the point that I just made, if they really wanted to, or really intended to rely on any of the oral representations, it's surprising that there's no document that follows up and just says, well, look, we want to be right about what you've said. And I think the force of those comments were recognised by my learned friend in his oral opening in response to Your Honour, and I've given the reference for that there. So if ALAWWAL wanted to rely on any of the alleged oral representations, in my submission one could reasonably have expected them to have followed up and confirmed those in writing, not least given its sophistication and its understanding of these things, but it didn't do so. And Your Honour has the point that I made in that respect in the example with the oral default representation. If it was so important to you, one would have expected to see some form of follow-up to confirm it. The second point is in respect of the written representations, Your Honour. And in my submission, there is no basis for concluding that ALAWWAL relied on those written representations either. And there's 4 aspects to this. And I've set those out, Your Honour, at subparagraph 2 of my outline submissions. The first aspect is that given in my submission is the generic nature of the RFP and the PowerPoint. We say it's unreasonable for ALAWWAL to rely on any written representations contained within them. And I've addressed, Your Honour, in my outline submissions on the nature of those documents in the context of whether the representations are actionable, so I won't go over them. The second aspect of that is the subscription orders which were signed by ALAWWAL. And if Your Honour just wants to have
just before we get on to the subscription orders.
Yes.
I have read this document, but I can't remember.
Do you place any reliance now on the subscription documents which were signed by your client on behalf of ALAWWAL?
No.
Okay.
Your Honour, I'd said this in my opening.
I thought you did. I just wanted to check
Yes,
that.
That's correct, Your Honour. On the order form that's signed.
Yeah, no, I
by-
understand that.
Yes.
Okay. Yeah, that's helpful. Thank you. Yeah, sorry, you were subscription orders.
Should Your Honour want one example in front of them?
Well, no, I mean, I know, by all means, look at them. I do know the difference between the two documents
Yeah.
that we're looking at. Yeah.
Well, it's 192 of the F bundle, should Your Honour
Yeah.
want it, but I'm sure Your Honour is familiar with that document.
Yeah.
And Mr. Malaika, I think, signed each of those documents, other than one, on behalf of ALAWWAL.
Yeah.
And when I cross-examined him on this, he did confirm that he would have read that document carefully, and he was aware and he understood what he was signing. And Your Honour will remember that the text in the middle of that, sorry, this is probably where it does make sense to have it in front of Your Honour. It's F192,
Yeah.
just so that I'm not misquoting it.
Yeah, I just got it up.
So it's, yeah, the text in the middle of the page, Your Honour.
Yeah.
What that shows in my submission by signing each of the subscription orders is that ALAWWAL, through Mr. Malaika, its CEO, is confirming that they have read and understood the prospectuses, i.e. the offering memorandum relating to the fund. And he thereby confirmed that ALAWWAL read and understood all the detailed risk warnings that were contained in the OM, given that the investment in the fund including that the investment in the fund is one that carried substantial risks and was highly speculative. And we say that that's when he's signing this, as he accepted, that's what he's acknowledging and what he's confirming to have read and understood. Now,
I mean, just on this, I mean,
Yes.
the evidence is what it is. Just about everyone signs numerous documents saying they've read and understood things. And at one level, that may be true.
yes,
There's a gentleman who was a former partner at Clifford Chance who provides Twitter accounts, and in order to get access to them, you have to say that you've read and understood a whole load of documents.
yes,
As an experiment, he buried on about page 10 of 30 a statement that anyone who's read this far can be entitled to a free magnum of champagne. And it was something like, after 5 months and 7,000 people had signed them, the first claim was made for a bottle of champagne.
yes,
Now, as lawyers, we probably understand that we sign things at our own risk. On the other hand, just about everyone knows that terms and conditions, well, most charitably, may be read, but not all parts may be read as intently as others.
yes,
Now, in this case, it seems to me there is no doubt at all but that the claimant was a sophisticated investor. It knew full well that it was subscribing for units. It knew full well that the offering memorandum provided important terms in relation to that. If it needed that confirming, this document shows that that was confirmed, and it knew almost certainly, and Mr. Malaika said expressly that he did, that he was confirming that he'd read and understood it.
yes,
Sort of, as it were, take that as a given.
yes,
That doesn't answer the slightly separate question, which is how you look at statements made within the offering memorandum. You plainly can't ignore them.
Yes.
But it doesn't mean that you don't read the offering memorandum as a whole, that you don't look and try and understand what they would mean, and take into account at least some of the points I put to you about how people act generally.
Yes.
Now, I only put that out to you as it were,
Yes.
a reflection of. It sometimes seems to me that courts are unrealistic about how they parse individual words and phrases. I'm not suggesting you are in this case, but
Yes.
they can sometimes be a bit unrealistic about
Yes.
that. That's all really I'm asking for any comments that you've got about it.
Yes, there's a few comments I'd make on that, Your Honour. The first is that it goes with Your Honour's point about, well, if you sign something saying you've read and you've understood and you've confirmed, and you haven't, well, you're carrying the risk.
Yeah.
And where that does make a difference is here, where you're dealing with a sophisticated individual in Mr. Malaika, but more importantly, his institution.
Yeah. So if I as a lawyer sign something like that and I
Yes.
decide not to read it, well, that may be what a lot of other people do, but I know full well the risk I'm taking on.
Exactly, and it's not like, and it's one thing for a layperson to come up and say,
Okay.
well, I didn't read it.
Well,
But the other point that links to that, Your Honour, and it is an important point, is you can't ignore what has happened leading up to this point. And what we do know is, and we've seen the process through the BDC and everything else, you have Mr. Ali Ibrahim, who not only has read hundreds of these documents, these offering memorandums, not only has he worked on 20 to 30 of them, not only is his evidence that I know what's in them without reading them, including all the risks, this is someone who is reporting back and advising the investment committee in ALAWWAL, which includes their CEO who signs the subscription order, about what this investment is. So within the institution, whether Mr. Malaika has read it or not, he has Mr. Ali Ibrahim, who has. So those are the comments I would make.
Yes, so I understand those 2 points.
Yes.
Yeah, okay.
Your Honour, the third point I was on this reasonable reliance, the third aspect is about the, and I'll come on to deal with this in more detail in a second, but it's about the fact there are extensive disclaimers which were containing in all of the documents relating to the funds, as well as the documents relating to other funds that ALAWWAL was looking at, as well as documents relating to ALAWWAL's own funds. And I'll come back to those, as I say, in a moment, but we say that makes clear that ALAWWAL could not reasonably rely on any written representations. They know this is the standard, the industry standard. The fourth aspect, Your Honour, is there are emails in early January 2019 between ALAWWAL and Ribble. And I just want to deal with those emails because, as we understand it, one of the points ALAWWAL seeks to make is that Ribble expressly stated to ALAWWAL that it could rely on any alleged representation in the RFP, which is a proposition my learned friend says, and he relies on Taberna to say, well, that represents a course of dealings between the parties and it overrides the disclaimer. But just on the point of whether that email was an invitation to rely on the RFP, my submission is the construction of that is wrong. And what I'd like to do is just take Your Honour to that email. It's at F108. Now, the email's the one at the top, and the focus of it is the second part of it.
Sorry. Yeah, okay.
Sorry, Your Honour.
No, sorry, I was just looking at the wrong document for a minute. I've got it.
Oh, yes.
It's all right, I've got them.
Got that. F108.
Yeah.
So, Your Honour, we've obviously read this together a number of times during the course of the trial, but we're concerned with the bullet points. And I say that there is a clear distinction that is being drawn in the requests here, as one would reasonably interpret it, between what is your company or the company, which I would say is Ribble, and what is the Trade Finance Fund, or the fund. And I say that distinction is clear because the first one is obviously about your company and related parties, not the fund. Points 2 and 3 clearly about the fund and referred to by name. And again, the fourth one is information in relation to the company's risk management policies and procedures and controls, which is RIBL. Now, I won't take you on back to it, but we know the genesis of that request comes from a template due diligence that is sent internally at ALAWWAL that's then copied and pasted. But what my learned friend says on this, or what ALAWWAL says on this, is this represented us making a request about the company or the fund's risk mitigation measures. And it doesn't say that. First of all, as I said, it comes from a generic template that was circulated internally at ALAWWAL. Actually, perhaps, can you just give me the reference for that? It's a F102, Your Honour. So F102 is from Mr. George to Mr. Awan, and then we see it sets out generic questions, and then it says fund manager due diligence request list at the bottom, and then it sets out items, information about the fund, and then management information, and then risk management information in relation to the company's risk management policies and procedures and controls. So he's saying these are questions about the fund manager due diligence. The bullet point is verbatim on the next page, and that's copied and pasted into the email that's then sent. So there's no specific representation or request for information of risk mitigation measures.
Yeah.
That's not even the basis on which it's identified to be asked in the first place. It's just generic information in relation to the company's risk management policy. And my submission is the interpretation of that is that it's information about RIB. And if we then go on to, or sorry, just before, for what it's worth, I say that is the correct construction. And in fairness to Mr. Ali Ibrahim, he did accept in his evidence that that was a possible construction of the email that he sent. And I've given the reference for that in my note. But 114 is the response to this. Which is the email at the bottom from Mr. Ahmed to Mr. Ali Ibrahim. And he says, please see attached PPM certificate and incorporation registration. We'll send through the latest Sharia approval. We will need to sign an NDA to send through the latest financial statements. Let me send you our standard NDA to sign. Now Your Honour may think that there's you know, what's to that? But actually the use of our there, our standard NDA, the NDA is between RIBL and ALAWWAL. It's not between the funds. So at least Mr. Ahmed, when he's using the word our in that sentence, he's referring to RIBL. And then he goes on to say, our risk management policies are included in our RFP. Have you got a copy of that? And it's fair to say from his email, one could interpret that as him thinking they may already have been sent this document, but he's confirming. And then we see...
just on that, I think the evidence is... Sorry, there's no evidence that it had those policies before.
No,
Yeah.
no.
Yep.
And then we see the email above, Mr. Zografos comes back in and says, in addition to the information sent over by Harun, kindly find attached the most recent fatwa along with the Sharia structure, and a standard RFP includes our risk management policies. Please find attached our standard NDA. And again, I would say the use of the word our there is talking about RIBL. But importantly in this email exchange, Your Honour, there is no reference whatsoever to risk mitigation strategies, which is how ALAWWAL put the case. They say the email, our 2nd of January email to you, was a specific request for risk mitigation measures, and I say that's not true. And the response we get back here is not, please see attach a document which has all of the risk mitigation measures explained which you can rely upon. It's a standard RFP. I think RFP is probably the wrong name for it, but it's a standard RFP which includes our risk management policies, and we say that relates to RIBL. And what you don't see in these emails is any clarity as to why ALAWWAL are actually making the request, what it means by risk management policies, which is a very broad term in my submissions. And what these emails show is there's also no suggestion by RIBL to ALAWWAL that it could rely on any alleged representation contained in the RFP. All it knew is that it wanted information about the risk management policies, procedures and controls. It didn't know specifically what that related to. So all it's doing is giving information in that document that comes with the disclaimer in the back. It's not making any statements as to how the fund operates or where ALAWWAL could find information about the fund's risk mitigation measures. That overstates what this email exchange actually is. Your Honour, I'm just looking at the time. I don't know if this is a... I'm going to move on to my final heading under reasonable reliance. But
well, I think let's go on for a little bit. Why do you carry on?
Yes.
I know we're getting up to... I think we might go on until 22 or thereabouts.
Sure. I'm grateful, Your Honour. So my final heading under this topic of reliance is the disclaimers, which is really goes to reasonable reliance and actual. And I'm dealing with this separately because although it's relevant to both forms of reliance, both actual and reasonable, the disclaimers are also relevant to whether there was any assumption of responsibility by RIBL for any of the statements or any investment advice. So it's somewhat of an umbrella topic.
And just to get our language case, I take assumption of responsibility to be relevant to a claim, well, essentially a Headley Byrne claim, because that's what one's about.
Yeah.
You say assumption of responsibility both for misrepresentation claim and advisory duty claim. What do you mean by assumption of responsibility in the context of a misrep claim?
Well, that's how it's put by the other side. So they say there's an assumption of responsibility that RIBL assumed, A, for making the representations as well as advising generally. That's how the case is put.
Well, to perhaps turn it round another way, in order for someone to be liable for a misrepresentation, you don't have to assume responsibility to the other side for it. If you're a seller, you don't assume responsibility for a buyer, but if you make actionable misrepresentations, you can be liable for them.
Correct, Your Honour. I'm with you on that point. I'm not saying it is. That's how the case is put.
Right.
But the way I would deal with it is on the advice point generally.
Yeah, I mean, okay, fine. Well, all right. So I mean, so far as you're concerned, and if Mr. Adair wants to say anything about it, he can. So far as you're concerned, assumption of responsibility relates to
advice. What
I'd call a Headley Byrne case.
Yes.
Yes. Okay.
So Your Honour, there's 2 points on the law, but I think I may be able to take it quickly.
I mean, you can take it that I think I know and understand what you mean by two.
Yes.
And I think I can also, you can take it that I also understand what you say about 2B, and I've read to Bernard.
Yes. Well, Your Honour, I'm grateful for that indication. There's one other authority which we tried to find some other Commonwealth authority. It's the Hong Kong case of Dang Dan, and we say that.
Now, I did read the Hong Kong authorities. Which one was Dang Dan?
Yang Dan is where the plaintiff purchased an apartment. And
yes, it's the apartment where they were from
CB.
Canada, when they were Canada, and they wanted to have a view of Victoria Harbour. Yeah.
That's right, yes. So, Your Honour, I also rely on that, and we say that supports us in the same way that Taberna does. I'm happy to take Your Honour through that authority if it would be helpful.
Well, no, don't worry. I, as you can tell, I read it.
Yes. So then I can move on from my 2 points on the law. And we say the disclaimers in this case are effective in making clear that Ribble was assuming no responsibility for, and that no reliance could be placed upon any of the statements made in the PowerPoint and the RFP. And there's 3 points I make in respect of that. It's set out at subparagraph 3 on page 21. The first point is that the language of the disclaimers themselves clearly have the effect, in my submission, that I've just described. And Your Honour, perhaps if we can just look at this in the context of those documents. So if we can go to the PowerPoint first, F20, page 38. So the first one is just to notice, it's a full page, it's legible, it's headed disclaimer, it's clear what this is. But Your Honour will see on the second paragraph, starting on the second line, Ribble does not represent or warrant either expressly or impliedly the accuracy or completeness of the information or opinions contained, accepts no liability, and it goes on. And then the fourth paragraph is the prospective investors in the fund must obtain and carefully read the fund's most recent term sheet, offering memorandum, supplement, and any financial statements, as well as seek independent financial advice if required prior to making the investment. And then it goes on, the fund is intended for sophisticated investors who understand the risks involved in investing in the fund. And then it goes on, the information contained herein does not have any regard to the specific investment objectives, financial situation, or particular needs of any person. And Your Honour, in my submission, those statements make it very clear that Ribble is not assuming responsibility or accepting liability for any statements made within the PowerPoint, and that such statements should not be relied upon. And as we've seen, and I think as is accepted by Mr. ALAWWAL, that's fairly common in these documents. Presentations produced by funds, partly because they are generic documents that are not bespoke to anyone. So they can't individually verify the relevance or the accuracy of the information as it may relate to any specific investor. The next one is the RFP, if we can look at that, which is at 118, page 30.
Yeah.
So just before I get there, Your Honour, it's important to note on the RFPs specifically. If one looks first at page 2, which is the table of contents, this page is identified as an important note. That's what it's labelled as at page 2. I think the page numbering's wrong, but it's called important note. And then if one gets to page 30, we can see reflected at the top of that page is the important, and it contains the disclaimer. And similar to the PowerPoint second line, Ribble does not represent or warrant either expressly or impliedly the accuracy or completeness of the information or opinions contained within this RFP. It goes on about liability. At the end of that, it talks about the fact that information or opinions in this RFP are subject to change without notice. And then we see, as it goes on to the penultimate paragraph, the RFP is prepared for general circulation and is intended for general information purposes only, not intended as an offer or solicitation or advice with respect to the purchase or sale of any securities or investments, not tailored to the specific investment objectives or the financial situation or needs of any specific person. And again, in my submission, those statements make clear that Ribble is not assuming responsibility or accepting liability for any of the statements within the RFP, and that such statements should not be relied upon. Now, Mr. Ali Ibrahim's evidence on this is fairly important, because he says, well, I know all of these are there. I know they're there. I know what they say. I know what they commonly say without even having to look at it. And that's important because he was aware of it, and it leads me to my second point, which is the fact that the disclaimers are contained towards the back of those documents is not one that is material. And I think Your Honour asked that question in opening, and I took you to Werner as the authority on that.
Yeah.
So I won't labour that point. The other points that I make in respect of this, Your Honour, and I think it is an important point, is ALAWWAL had a significant amount of time to review these documents in full, including the disclaimers, before making the investments. And I think that is a material point that Your Honour should bear in mind. This is not a case of they were sent the documents and they had to invest in the next day. In respect of the PowerPoint, they had those for 4 months before the first investment was made in the fund. And in respect of the RFP, they had that for 2 months, almost 3 months before the first investment is made. So ALAWWAL had ample time to review the documents carefully, including the disclaimers, and it's not a case of them being rushed into an investment decision without having chance to consider what is said there properly. And as a sophisticated institutional investor, ALAWWAL could reasonably be expected to review the entirety of the documents carefully, including the pages containing the disclaimers. And Mr. Ali Ibrahim's evidence in particular was supportive of that. And we say all of that in any event is underscored by ALAWWAL documents, which are sent out to their own investors in respect of a trade finance fund, which is subscribing to the RASMALA fund, which has the same types of disclaimers. And I won't take you to it, Your Honour, but the reference for that is just G2253, and I've set that out in my note. The other point that also underscores that, beyond ALAWWAL's own marketing documents, is the fact that every other marketing document, including presentations by AGC and Barak Ibdar and so forth, all contain the same disclaimers. So they will be very much aware that this is what is being said consistently and commonly by all funds, advertising and marketing similar types of investments. Now, the next point that I want to deal with, and the last point on this, Your Honour, is my learned friend suggests in his skeleton argument, and again in the submissions, that the disclaimers were unreasonable and that Ribble could not rely upon them because of the implied terms in contracts and unfair terms law. I'm not sure if that argument is still pursued. I assume it is, and if it is, in my submission, it's wrong. Because the argument is based purely on the alleged 2nd of January representation, which I've already addressed Your Honour on. And we say there's no representation by Ribble in those emails that ALAWWAL could rely on the RFP. But in any event, if one just looks at the implied terms law very quickly, Your Honour, it's E1 tab 3, page 15.
Yeah.
Your Honour is much quicker at navigating the bundle than me.
No, sometimes I just happen to have got there first.
As with all things, Your Honour. Negligence liability 37 is what I'm looking at the top of the page. So Your Honour will read it. It's obviously the second.
I've read it.
You have it. I'm going through, Your Honour. But Your Honour, what is relevant to this is Schedule 2, which I don't think you have been taken to, which is at page 21. And these are the guidelines for application of the reasonableness test.
These, I haven't read them in this context before, but they're very familiar.
But exactly, Your Honour is right. But things such as the strength of the bargaining positions, taking into account the alternative means by which a customer's requirement could have been met, this is very much a case where we say Ribble and ALAWWAL had equal bargaining positions. And ALAWWAL plainly had a number of alternative funds it could have invested in, and it did with AGC.
But just on this, your point is that if one gets to the reasonableness test, there's nothing to show that they're unreasonable.
Yes, exactly.
Yeah. Okay, well,
The
I
short
understand
principle.
you're not saying that one couldn't apply the reasonable test.
Yes.
Reasonable test. You're just saying that if you do, you get to only one result.
Exactly,
Yeah.
that's right.
Well, I mean, I understand that point.
Yes. Well, that neatly brings me on. I've gone 2 minutes over, Your Honour, but
That's
concludes
helpful.
my
Um,
submissions on reliance.
Now, look, we're just past 22. How long do you think roughly you're going to be?
I think on the time allocation, Your Honour, I'm due to finish by 2:50 or 2:40. Sorry, I should finish by then. I think what I'm going to do, subject to any comments from Your Honour, is come back next to focus on the regulatory
Fine.
claim.
Okay. And just in terms of timing, I'm not quite sure. It may be that we may have to have a slightly longer break because there's one thing which I've just got to do between. Well, it may be that the break will have to be as long as half an hour between 5 to 3 or so forth. But if that's the case, we'll obviously go on a little bit longer.
I'm grateful, Your Honour. Your Honour, what I may do is subject again to anything Your Honour said. In respect of advisory duty, I have set out my submissions in my outline submission on that. I've taken on board what Your Honour has said.
Yeah. Well, I mean, for what it's worth, you quite your own course.
Yes.
I'm not sure that I'm going to be assisted by all that much
Yes.
on advisory, but anyway, that's up to you.
I'm grateful. So what I may do, Your Honour, is just I think what I do need to focus on
Well,
is
you
the
need to
regulatory
you
duty.
need to look at the regulatory duties.
Yes, and I also need to look at causation and quantum. So I may focus on those, and then the rest are in writing.
All right. Well, look, we'll come back at 1:45, and as I say, we depending on it, it may be that we'll have to have a slightly extended mid-afternoon break. But if we do so, we'll take up the difference between 10 minutes and whatever time it is at the end.
I'm grateful. Thank you, Your Honour.
Yes.
Thank you, Your Honour. Your Honour, I'm going to deal with advisory duty, the point very quickly, and then move on to regulatory duty. I just want to go back to something Your Honour and I were discussing before, which is the terminology of assumption of responsibility.
Yes.
I just wanted to go back and check what the positions were between the parties, and there is common ground on it. But the position under DIFC law is that an assumption of responsibility is required for both a claim and misrepresentation as well as an advisory duty claim.
Right.
Albeit the nature of the assumption differs. If I can ask Your Honour to go to E2 tab 6, page 11.
Yeah.
This is Article 20.
Yeah.
Your Honour will see where a claimant has suffered only pure economic loss.
So page 20.
Yes, sorry, page 11, Article 20. So Article 20 deals with a pure economic loss claim, like ALAWWAL's claim.
Yeah.
And it's 1B, and...
Yeah, so that's what I would call a Hedley Bird duty.
Yes, well, 2 is specific. So what 1B is the assumption of responsibility in such claims, which would cover the advisory duty claim where they say there's an assumption by Ribble to advise ALAWWAL on the investments generally. And number 2 deals with what is called the misrepresentation claim specifically. So Your Honour, we'll see, it provides there'll be an assumption of responsibility where the statement is made and then the 2 subparagraphs are applied. And I understand that that is the position that's taken by
Yeah, I mean, looking at this, it looks to me, I mean, this is how I read it, as if 21B
yes.
is the requirement for an assumption of responsibility in order for what I'm terming a Hedley-Burn duty, but obviously plainly in this context isn't a Hedley-Burn duty, but it's the duty equivalent to Hedley-Burn to arise. So that's 21B.
Yes.
22 is a misstatement case. Let's just look at. Sorry. 22, it seems to me, is assumes the responsibility in a rather different context, because it says that he assumes it's made of he knows that it will be communicated, he intends. And Article 20 is where, sorry. Yeah, so. Yeah, I see. So actually, it is rather different. One I think one has to be careful of thinking about this only in terms of what one call the common law of misrepresentation.
Yes, correct. Yeah.
It probably gets to the same result, but it is rather different.
It is, yes.
Okay, well that's helpful. Thank you very much.
I'm grateful.
And unsurprisingly, this is common ground between the parties.
Yes.
Well, it's good that you told me that.
Yes.
Good.
So Your Honour, on the advisory duty points, I deal with this at paragraphs 35 and 36 of my outline submission. I'm not going to repeat that, which I'm sure invites a sigh of relief from the court. But what I do want to focus on, just briefly, Your Honour, is a point I make at number 5, which is the alleged advisory duty to advise generally on the investment is inconsistent with the contractual relationship that the parties ultimately entered into. Now, Your Honour, I don't understand it to be in dispute that the accounts that ALAWWAL opened with Ribble were non-discretionary accounts, in relation to which Ribble provided execution-only services rather than discretionary management services. And that was the evidence of Mr. Bitcon, paragraph 6.14 of his witness statement, and I don't think he was taken to that. And if we look at the business terms of business, it's clear that no advisory duty was owed by Ribble when performing.
Does your point come to this, that all you were doing on the contractual terms was executing instructions expressly without advice?
Yes. So my learned friend, during the course of the trial, focused and took the witnesses all to 3A, but actually the one that applied was 3B, which is execution only. And that makes clear that if we're acting on the instructions of ALAWWAL, we're not obliged to assess the merits of the decision, any decision to invest are entirely their own, and so forth. But even 3A, even if you're under 3A, ultimately that says, the ultimate decision, the responsibility for the decision to invest is the investors. But in any event, 3B is the relevant one. It's execution. We're not doing it. And why I say that is important, even though these terms of business relate to the period after which the accounts had opened, is because prior to the accounts being opened, and at a very early stage, they were sent the terms of business. They were sent them on the 29th of November 2018. And that's the email there is at F43 for Your Honour's record. So it's sent after the first meeting on the 14th of November. So it would have been clear in my submission to both ALAWWAL and Ribble that even if Ribble ultimately provided investment advice, it would not assume the responsibility for such advice. But Your Honour has my points at paragraph 36 more generally as to why we say the advisory duty really could not have arisen. With that, Your Honour, what I'll do now is move to regulatory duties, which is a bit more of a substantive topic. Your Honour, I raised at the outset about the pleadings, and I say that applies with particular force once one really drills into what the regulatory duties claim is. So I'm going to have to take Your Honour through the pleadings on some of this. And what I'd like to do is start off at paragraph 66.
So just to be clear,
yes.
When you say this applies particularly, are you referring to the aspects of so in your 5 respects of departure from the pleaded case,
yes,
one of them is 4.2.2 of the DFSA rule book,
yes,
and one of them is 41B of the regulatory law,
yes,
which I think are the ones to do with the regulation. Is that what you're referring to?
That's part of it, yes. Your Honour has the pleading points on that. But also, actually, when I take Your Honour through these, you'll see the regulatory duties claim is actually very limited and narrow in terms of what is said to constitute a breach of a particular duty.
Yeah. Okay.
So, Your Honour, the first point is the page 35 of A2, which is the amended particulars of claim. Paragraph 66, we've looked at this before. So it just says the oral fund risk representations, oral default representation, written fund risk representation were false and were made negligently and or in breach of the duties and or in breach of RIBL's statutory duties to ensure that communications with RIBL were clear, fair and not misleading and or were made with a degree of care and diligence and reasonable exercise. So we're just concerned with the first part, which is clear, fair and not misleading. And that is a reference to COB 3.2.1. Which my learned friend has addressed you on. And we say there is no breach by RIBL of COB 3.2.1 in respect of the alleged representations. Now, Your Honour may want to look at, 3.2.1 again. It's at E2, 3, page 29. So, when communicating information to a person in relation to a financial product or service, an authorised firm must take reasonable steps to ensure that the communication is clear, fair, and not misleading. And there's 2 points that I make in respect of that. The first is the obligation is not, as ALAWWAL alleges, a strict obligation to ensure that communications are clear, fair, and misleading. It's an obligation to take reasonable steps to ensure that. And the second point of that is we say if Your Honour agrees with me that the alleged misrepresentations were not made or they were not actionable or they were not false, it follows that RIBL will have complied with their obligations in this respect. The second point, Your Honour, the second allegation of regulatory breach being made in paragraph 66 is that RIBL the duty of care owed by a fund manager. And a lot has been made of this. I was actually unsure about whether the point was still pursued as at the opening of the case, but it appears it is. And what that is, Your Honour, that is a reference to Article 22, subparagraph 2 of the Collective Investment Law. And Your Honour will see that from paragraph 68 at page 36 of the amended particulars of claim. Now, we say that a duty of care has no application here and therefore cannot have been breached by RIBL. And I say that for 2 reasons, Your Honour. The first of which, if you're with me, effectively shortcuts the point altogether. And doesn't require Your Honour necessarily to make any finding about whether RIBL was acting as a fund manager or not. And my first reason is that under the collective investment law, the duty of care owed by a fund manager only applies in relation to activities that the fund manager carries out in relation to the management of the fund.
So they're by definition not investment duties.
Correct, Your Honour. And if we can look at that, it's E1 tab 4, page 1, please. Sorry, not page 1, page 15.
Sorry,
E1 tab 4, page 15.
Yeah.
And Your Honour will see it's Article 22 that in exercising powers in carrying out its duties, a fund manager shall, and then it's B, exercise a degree of care and diligence as a reasonable person would exercise if he were in the fund manager's position. So the duty of care under this article applies where the fund manager is exercising its powers in carrying out its duties. And I say, well, that begs the question, what counts as an exercise of a fund manager's powers and duties? And we find the answer for that just above. and this is chapter 2, which is called Duties and Function, 22, Fund Managers, General Duties and Functions, and then sub-paragraph 1. A fund manager of a domestic fund shall, and then it goes on, Your Honour, manage the fund, including the fund property in accordance with the fund's constitution, most recent prospectus, perform the functions conferred on it by the fund's constitution, comply with conditions or restrictions imposed by the FSA, comply with any requirements or limitations imposed under this law, and so forth. So all of that is talking about activities that the fund manager would carry out in managing the fund, i.e. in relation to units held by unit holders who invest into the fund. And those are the activities in my submission to which subparagraph 2b applies. And I say that interpretation is supported by the provisions at 2c, where we have a 2c, 2d, 2e, 2f, and it goes on, Your Honour. But if one looks at all the subsequent provisions, they are all concerned with the protection of unit holders and their investments in the fund while the fund manager is managing the fund. What the duty is not concerned with here, as expressed, and this is the crucial point, is the activities of a fund manager prior to an investor investing in the fund. So the alleged duty of care under 22.2b, which is relied upon, in my submission, simply has no application, because ALAWWAL's complaint is not a complaint that Ribble mismanaged the fund to the detriment of unit holders. It is that Ribble made misrepresentations prior to ALAWWAL investing in the fund at all. And in my submission, that renders irrelevant the question of whether Ribble was acting as a fund manager, because even if it was, the duty under 22 sub 2 sub b cannot have been breached. Now, the second reason on this point, Your Honour, is we say in any event there was no breach of Article 22b, because Ribble was not in any event the fund manager. Now,
I mean, does this go further than the discussions I was having with Mr. Adair yesterday about the legal accountability and the first part of Article 22?
I'm not sure it goes further on it, but it's obviously relevant to the point. And there's two requirements, as Your Honour knows, that ALAWWAL must satisfy to establish that Ribble was the fund manager. First, it must prove that Ribble was legally accountable to the unit holders, which is the point Your Honour made, for the management of the fund, including the fund property. And second, it must prove that Ribble established, managed, or otherwise operated or winds up the fund. And what Mr. Adair says is that if subsection B is satisfied, then it follows that A must be satisfied. And I say it doesn't work like that, because the requirement is for them both to be satisfied. Your Honour, the Article 22, Your Honour, is at page 14.
Yeah.
Of that. So those are cumulative requirements, and ALAWWAL, we say, must prove both. And we say it's failed to prove that either requirement is satisfied, but specifically in respect of the first requirement, there is no proper basis that's pleaded, or in my respectful submission that my learned friend was able to explain, as to why it says Ribble is legally accountable to the unit holders. Now, in my submission, the words legally accountable denote that there must be some form of legal relationship between those managing the fund and the unit holders, and by which the unit holders must then have a right of recourse against the person managing the fund. So there's no identified basis on that, and I take on board Your Honour's observations yesterday about, well, what is meant by unit holders? Is it as a class as a whole, or is it individual? And that's not clear. But there's a couple of points I want to make on this. Yesterday in his submissions, what my learned friend attempted to say, and to get around that, is to suggest, well, yeah, there may be a claim against Ribble if Ribble was acting as the de facto director. And I think Your Honour posited it as perhaps it's a shadow director claim. There's 2 points I want to make on it, and they are important. The first point is that's not how the claim is pleaded. It's the drum that I keep banging that is important. The second point is, if it was, Your Honour, the question of de facto or shadow directorship, in my submission, is one that can only be determined by reference to Cayman law. These are directors serving for a fund that's incorporated in the Cayman Islands. But in respect of the legal accountability, that, in my submission, can only really come from a relationship that exists between the unit holders and the directors of the fund, who are the ones that are managing it. And that claim probably lies under the Articles of Association and possibly the offering memorandum, which says the directors are the one responsible for managing the fund, and they are the ones who are delegated with the task of doing so. So we say 22A, there is no basis for saying that it's Ribble that is legally accountable to the unit holders. That must properly be understood to be the directors of the fund. Now, in respect of the second requirement...
I mean...
Sorry.
No, I mean, I'm just focusing on the words legally accountable.
Yes.
I mean, to my mind, they're odd words, even in the context of directors. I mean, let's just use your word. The person who manages a fund is the person who's legally accountable to the unit holders for the management of the fund. Well, if you use accountable, as I think you did just then, as being liable for losses, even in respect of directors, that is at best a rather inaccurate snapshot. I'm only really making the point, legally accountable is an odd phrase in this context.
It is. I would agree with you on that. But if we can...
Sorry, just on that.
Sorry.
I think I asked Mr. Adair this, and I think he told me we don't get any help from any other jurisdiction about these words. But
yes.
I'll put the same point to you, because they do strike me as being odd, and if
yes.
there is some origin for them, I wouldn't mind seeing what it was.
No, not that I've been able to find, Your Honour. But on just on that, if we can explore that, and I agree with Your Honour about managing and liability for the loss. But if we take it, let's say, legal accountability as an odd phrasing, but let's look at what that means. Now, if the unit holders, individually or collectively, had an issue with the way in which the fund was being managed, which is the directors, now, there are, depending on the jurisdiction, steps that are available. So, for example, if the directors were acting in a way that was prejudicial to any specific unit holder, it is usually available to a shareholder to bring some form of an unfair prejudice claim, potentially, or any other one. Now, if you look at it in the context of Ribble as the investment manager, there is no right that exists either in my submission, commonly in statute, to remove them as the investment manager, or to bring a claim against them for anything else. If there was a claim by a unit holder against Ribble, it would necessarily have to be a claim against the director for their appointment of Ribble as the investment manager. And I think that's how I say it tracks through, that ultimately legal accountability, whatever it means, must mean some form of recourse against the director, not against Ribble. And in respect of the second requirement, Your Honour, we rely on the investment management agreement, and we rely on the offering memorandum as saying...
Just before we get to
yes.
that, I mean, I know you rely on the investment management, but do you agree that 2B is a factual question?
Yes, I think I would agree with that.
Now, obviously, you say, well, the first thing you look at is what the legal responsibilities were.
Yes. You don't get to B unless you cross A.
Well, no, that's not the point I was making. I got your point that you don't get to B, not A. Now, I was meaning that if you're looking at B specifically, who establishes, manages, or otherwise operates or winds up the fund, the first thing you do is look at a legal question.
Yes.
It's just that on that, I would suggest that you don't begin and end with the legal responsibility, because it's actually ultimately a factual question. I haven't put that terribly clearly. Let me try again.
Yes.
B is ultimately a factual question.
Yes.
In looking at who establishes, manages, or otherwise operates or winds first thing you do is to look and see whether there are any contracts which deal with that. However, those contracts will normally be equivalent to what actually happens, but they may not be. That's the point I'm putting to you.
Yes, I see what you're. This is what I think my learned friend refers to as the window dressing laws.
Yes.
Yes. So if I understand Your Honour, the question is, B is actually you're looking at a factual analysis of everything in the round. You're not limited to what is in the contractual documents. Yes, I would agree with that, but I would say that the contractual position is the right place to start.
Yeah.
And what you have is, and I say there's a number of points in this respect. The IM is but one document that I rely upon to show, well, there was a delineation here between the investment manager who was charged with marketing the fund and running the investment program, and the directors who were doing that. And the offering memorandum, we say, is one such document that confirms ultimately the directors are responsible for managing the business of the fund. And I say that's reflected in the Articles of Association, which again make clear that it's the directors who are responsible for running. I say it's reflected in the minutes of board meetings of the fund, all of which show the directors are present and are ultimately the ones making the resolution, even if it's on advice from others. And when the letters were going out to investors, for example, it's again, they're signed by the directors, and that says, in my submission, that says ultimately who's managing it and operating it is the fund, the directors. Now, on that, one of the points that my learned friend makes, and I think he's made it both in closing as well as to my witnesses, is that, well, everything you were doing shows that you were managing the fund. And I say that's not correct, because one has to understand what managing the investment program means. So one of the points is made as well, Mr. Bitcon was running or involved in the litigation that was brought by the fund. And I say that's correct, he was. In respect of Metrade, that's obvious, he was given a power of attorney. But Your Honour, what we can't lose sight of is that the Metrade transaction is an investment of the fund. So Mr. Bitcon, working with Ribble as the investment manager, is protecting and looking at that investment and trying to bring the recoveries. So it's not surprising he is involved in the litigation as part of the investment management team. We say that doesn't show he was operating or managing the fund, it shows he was managing the investment, which is the transaction with Metrade. And it's the same in respect of Farlin and the litigation, his involvement, if any, with that in the insurance companies. And again, the other example that was given is, well, you were involved in accounts. Well, that's not strictly true. It's the administrator and KPMG who were responsible for them. But it's not surprising that a fund whose business is giving out trade finance transactions, that the investment manager who's responsible for managing those transactions is going to input into the accounts. So we say they don't really demonstrate that there was management or operation. And if one looks at the contractual documents, if one looks at the articles, it's clear that in terms of establishing the fund, that was RML. And in respect of winding up the fund, that's the directors who have the right to do that. And in terms of managing or operating, the directors are there at the meetings, supervising what's going on, delegating authorities to Ribble as the investment manager, auditors, delegating responsibility to administrators. That's how these things are run. It doesn't mean it's not the directors who are managing it and are overall responsible and supervising it. So we say that even if Your Honour gets to having to make an assessment as to whether Ribble was the fund manager, in my submission they were not, and therefore this part of the claim we say should be dismissed. Now, if I may move on to my next regulatory breach, this is at 67 of the particulars of claim, at page 36. Now, the allegation here is a very specific one, and it's limited to one representation. And the allegation is that the RFP legal action representation, that in making that, Ribble has breached Article 52 of the Collective Investment Law and COB 3.2.1. Now, Your Honour will be familiar that the RFP legal action representation is a reference to 5.6 of the RFP, which is where it said that the company, i.e. Ribble, has not taken any legal action against other entities or individuals during the last 2 years. Now, I can take Your Honour to that if he wishes, but I don't need to for this, what I say is this simple reason. The allegation has no basis, because in the particulars of claim at page 20, paragraphs 34 to 35, ALAWWAL admits that on a strict interpretation of the text, paragraph 5.6 only refers and related to Ribble and not the fund. Now, if it accepts that on a strict interpretation of the words that are used, that this is about Ribble and not the fund, it's not clear to me how it can then go on to say that's unclear or unfair or misleading, because what I was expecting is to see something about the fund. Those two don't quite marry up. And I say that's a puzzling argument, because it accepts, as it does, paragraph 6 is clear on its literal and strict interpretation. So then there's no objective basis on which it can be said that Ribble has breached COB 3.2.1 or Article 52 of the Collective Investment Scheme. And one other point I would add on to that, Your Honour, is even if there had been any ambiguity, and I don't accept there was, and in fact ALAWWAL doesn't say that there was, we say that would have been remedied by the provision of the 2017 accounts, which made clear that there was at least legal action being taken in respect of Medtrade. So that's a further reason why we say there was no breach of COB 3.2.1 or Article 52. The next allegation is paragraph 69 of the particulars, which is at page 36. And this is that Ribble breached Article 52 of the Collective Investment Law by the written representations alleged to have been contained in the RFP, or sorry, the falsity of the written representations alleged to have been contained in the RFP, and by failing to disclose the Medtrade litigation in the RFP, the PowerPoint, and the offering memorandum. If Your Honour just bears with me. If I can, well, let me just say there are a few short answers to these points. The first point that I want to make, and I'll take Your Honour to it in a second, is that Article 52 has no application because it only applies to the marketing of a domestic fund, and this fund is not a domestic fund. If Your Honour, if I can ask you to please go to E1 tab 4, page 33. We can see at the top, it's Chapter 2, Marketing of Domestic Fund. 51's prospective requirement, 52 is prospect content, and that's what this claim is brought under. And it's the presentation of the information in the prospectus shall be clear, fair, and not misleading. That's what's relied upon. Now, domestic fund is defined in Article 13 of the Collective Investment Law, which is at page 9 of this document, should Your Honour want to see it. But it is one that is either established and domiciled in the DIFC, which this fund is not, or it's an external fund as defined in Article 14.1. And an external fund is one which is established or domiciled in a jurisdiction outside of the DIFC and is managed by a fund manager, which is an authorised firm. And for the reasons I've already submitted, I say that's not Ribble. They were not the fund manager. So therefore, if Your Honour is with me on that, this is not an external fund, and by extension, it's not a domestic fund. And in those circumstances, Article 52 does not apply. However, even if the fund was a domestic fund, so if Your Honour was to find, for my learned friend, that this is an external fund, in my submission, they still can't get home on proving there's been a breach of Article 52. Now, if we go back to it at page 33, what Article 52 requires is that a prospectus be clear, fair, and not misleading, and that it contain information which a person and his advisors require and expect to find in a prospectus to be available to make an informed investment decision. Now, the RFP, contrary to what Mr. Al-Ibrahim tries to say in his witness statement, is not a prospectus. The definition of a prospectus is in Article 53, which is at the page above. And so 50 sub 3, a prospectus includes, except where expressly stated otherwise, an information memorandum in respect of an offer of unit of an exempt fund or qualified investor fund, a supplementary or replacement prospectus, and in the case of an external fund or foreign fund, the units of which are marketed in or fund the DFC, any prospectus or other disclosure document prepared in accordance with the laws applicable to the external fund or the foreign fund. Now, we say the RFP as a standard marketing document does not fall in that definition. And as regards the offering memorandum, it cannot be said that was unclear in any way or did not contain all the reasonable information. In fact, ALAWWAL does not identify any inaccuracy in the offering memorandum. And it doesn't say its claims in misrepresentation are based on anything said in those offering memorandums. So it can't be said that that's unclear, unfair, or otherwise misleading. And it would not have been reasonable in my submission, if I need to go there, for the offering memorandum to include any information in relation to defaults or litigation that the fund was engaged in, because that's not the purpose of an offering memorandum. That's the kind of statement that is usually set out in financial statements, because offering memorandums, you have to formally update them, you have to file them with the regulator. You're not going to keep updating it to say, okay, there's been a past due or a default or a litigation in this respect, and then when that finishes, you're going to amend it again to remove it and then include it again. That's not what the purpose of that document is. It's to set out the terms on which an investor is investing in the fund. So we say the claim under Article 52 must necessarily fall. Now, the final allegation that's made in respect of the regulatory...
Well, just before we get there,
yes,
just one point. Can you go to E1 4 at page 10?
Yes. Yes.
14 is the definition of an external fund.
Yes.
An external fund is a fund which is established or domiciled in a jurisdiction other than the DFC. Well, that follows because it's Cayman and therefore it's not.
Yes.
And B, managed by a fund manager, which is an authorised firm. Now, in your case, that doesn't apply because it's managed by the directors and they're not authorised.
Yes.
But on Mr. Adair's case, it isn't an external firm because it's managed by Ribble, which is an authorised firm. Is that right? Sorry. Not is he right to say, but is that what 14.1 means?
Yes. Well, sorry, Your Honour, I'm not sure I follow the point.
Sorry.
It means
let me make it simpler. It looks to me on that basis as if on Mr. Adair's case we'd be looking at what the requirements of an external fund
yes.
are.
That's as I've understood Mr. Adair's case, that's right.
Right. And your point in relation to that is twofold. One is that comes back to the question as to whether or not who's the fund manager.
Yes.
And then you need the express application because of 14.2.
Yes.
The requirements relating to domestic funds don't apply except to the extent required.
Yes, well, even on the Article 52 claim, Your Honour, I would say even if Your Honour was against me and was to find that this is an external fund that's being managed by Ribble. I'd say there's no claim under Article 52 because that concerns prospectuses, and what you don't have here is a claim about the prospectus being unclear, unfair, or misleading.
Yeah, okay, all right. Sorry, I interrupted you. Yes, so you're going on to the next claim.
Yes, the final allegation is the regulatory breach related to Article 56, 1 and 2, and that's at paragraph 70 and 71.
Yeah.
And what ALAWWAL is pleading there is that the written representations, the falsity of the written representations and the RFP legal action representation means that Ribble breached Article 56, 1 and 2. Again, we say there are a few short answers in relation to these allegations. If we can go to Article 56, please, Your Honour, it's at page 36 of the same document.
Yeah.
And you can see, again, Chapter 4, misconduct in relation to domestic and foreign funds, misleading and deceptive statements. A person shall not make an offer of units if there is a misleading or deceptive statement. And then sub-Roman numeral 3, and any other document that relates to the offer or the application form. So Article 56 only applies, in my submission, to deliberate misconduct. And it's the point that I made yesterday in respect of Article 41B. ALAWWAL advances no case that Ribble made any false statements deliberately. So I would say Article 56 doesn't apply.
Yeah.
And Your Honour, I won't repeat the submissions I made yesterday about the difference between misconduct and negligence, that they would apply similarly to Article 56. Now, the second point that I make is Article 56 only applies where a person is making an offer of units. And an offer of units, Your Honour, is defined in the law at Article 19, which is at page 12.
Just read out the definition.
It's quite a long definition.
Oh, don't read it out, I'll look it up.
Where it is. It's 19, page 12.
Oh, sorry. Yeah, okay.
Yeah, so 19.2, my submission offer of units is effectively an offer to contract by way of an investment in the relevant fund. And 19.3, that may be done by way of an advertisement or other form of promotion, but it still may be an offer to contract. So in my submission, this wouldn't include the RFP, since there was no offer to contract within that. And in fact, the disclaimer, which I can take Your Honour to if he wants, but the reference is in my outline submission. The disclaimer makes clear that that document is not an offer or solicitation or advice with respect to the purchase of any securities or investments. So we say that definitely doesn't apply to the RFP. And the last and short point on that, Your Honour, is in any event, I say the alleged written representation, written representations, or the RFP legal action representation was not misleading or deceptive in any way. So, Your Honour, that concludes my submissions on the regulatory duties. Now that leaves fiduciary duties, causation and loss. Now fiduciary duties, if I may just deal with that very briefly, I've set that out at 43 to 45. I don't propose to go on it and in detail.
Look, I mean, I've read what you say.
Yes.
I've read, no disrespect, what relatively little Mr. Adair has to say about this. It doesn't seem to me at the moment that fiduciary duties is at the heart of this case. But
yes.
I have got your points. I'm not going to stop you making any other points you want to. But
no, there's no other points I want to make, Your Honour, other than to emphasise what I say at 45 of my outline submission, which is there's the two fundamental flaws, but I don't need to say more than what is said there. So, Your Honour, the remaining topic for me to deal with is causation and loss.
Yeah.
Just before I get onto that, I realised at lunch, just before, I promised the last one before I get to it. There was something I had not addressed you on, which I said I would have, which is this email to Miss Vias.
Oh, yes.
Now, before I get to it, Your Honour, and it's my own shortcoming and ignorance, but I'm not quite sure where that is actually relevant to or where it falls to. But what I want to do is, so, as in I don't know how they rely on it, but what I want to do is just take you to the document that I think is relevant. Because what my learned friend kept saying is that, well, Mr. Zografos has shortcutted the proper process. I'm not quite sure what that means or how, but in my submission, it's not based on a complete consideration of the document. So if I can start off first at F172, please. So this is the this is the email that is sent on the 19th of February by Mrs. Ogfos to Miss Vias. And you're on a question 5, which is the investment objective if the entity is moderate growth and risk tolerance is low medium, bearing in mind, please confirm security. So that actually reflects what has already been said by ALAWWAL in the client form, and that's what she's basing her question on. And Mr. Zogfos says the risk tolerance is high, but if one actually looks at the email as a whole, number 1 is the nature of the relationship with we're looking to invest in TF real estate, and number 6 again, this is not limited to trade finance. It's limited. It includes other investments that were being looked at. So this isn't an email that is just about the trade finance fund, but in any event, what is the consequence of his representation to Ribble? That's what we need to look at. And I don't think Your Honour's been taken to this document yet, but it's G2051. Which is the client classification form for ALAWWAL. And if Your Honour goes to page 5 first, you can see this is signed by Miss Vias on the 3rd of April. So it's after the email.
Sorry, G05?
Sorry, G2051.
Yeah.
And then it's page 5 of that document.
Last page.
Last page, yes.
Yeah.
So it's just to highlight, it's a document signed by Ms.
Yeah.
Vias and the date of it there. Now, if we go to page 4, under suitability, we can see that the investment objective of the client is to have moderate growth of his investments, and then under risk tolerance, as per the account opening form, the risk tolerance is medium risk. So I don't know what the relevance of the earlier email is and how it fits into the claim.
Sorry, excuse me, I'm not seeing anything on any signature or any completion. Am I the right one? 205?
Yeah, 2051. It's her name and it's signed at the bottom, but it's not signed, but it's completed.
Okay, sorry, I think you said sign. I was looking for a signature.
But this is the suitability assessment that is completed by Ms. Vias, Your Honour. So I say that just completes the circle, which is whatever Mr. Zogfos may have said in his email. In terms of the suitability or what's assessed as the risk tolerance by Ms. Vias in this form is medium risk, which is what was completed on the account opening form. So, Your Honour, with that, I'll move on to my final topic, which is causation and loss.
Yeah.
Which is dealt with from paragraphs 46 onwards at page 25. Now, there's 3 headings I want to deal with under this. The first is whether any of the alleged breaches of duty or regulatory provisions caused ALAWWAL to invest in the fund. The second is the cause of the losses to ALAWWAL's investments in the funds. And the third is ALAWWAL's claim for a loss of an alternative investment opportunity. Now, in terms of my first heading, in my submission, even if ALAWWAL were to succeed on liability in relation to any of its claims, it would still need to prove the alleged breaches of duties or regulatory provisions caused it to invest in the fund. And I emphasise that because while I have addressed you on whether ALAWWAL actually relied upon the alleged representations in the context of the misrepresentation claim, which is effectively a causation requirement, it's important to not lose sight of the fact that ALAWWAL must also establish causation for its advisory duty claim, its fiduciary duties claim if it's pursued, and its regulatory duty claims. And I don't propose to take you to the provisions, but the relevant provisions are set out
No, I
in
mean,
my note.
I see what you're saying about them, and I see the provisions you're effectively saying that the alternative causes of action aren't a shortcut to,
Yes.
well,
Correct.
to reliance or to causation.
Exactly. Your Honour's got the point.
Yeah.
So in terms of if I move on to my second heading, what we say there is there are, at the moment, before Your Honour, 3 competing theories or submissions that have been offered by the parties as to why ALAWWAL's investment in the fund suffered loss. The first is what my learned friend says, or said in his opening submission, that the cause of the losses was the failure by the fund to apply the relevant risk mitigation techniques. The second theory, which I don't know if it's seriously pursued, but my learned friend I think suggested yesterday that the fund somehow was living hand to mouth and using monies from ALAWWAL to feed redemptions as, I think he said, almost becoming a Ponzi scheme.
Yeah.
And the third is our case, which we say the predominant cause of the losses to the investments in the fund was COVID. So I just want to briefly look at each of those points in terms. Now, on the first point, as I've already submitted, ALAWWAL has not taken, Your Honour, to any evidence that the risk mitigation techniques were not applied by the fund to the transactions to which they were exposed. And we say that's evidence, when that you can look at evidence that they were when you look at Metrade and Farley. So we say that deals with that point. Now, as to the second one, there's obviously no basis for suggesting the fund was anything approaching a Ponzi scheme. That's a serious allegation. It's not been made before. It's not pleaded. There's no evidence in respect of it. So that takes me on to my third theory, which is my client's case. And we say that there is evidence before Your Honour that demonstrates that COVID was the effective cause, the predominant cause, of the losses in the funds. Now, there's 2 documents I want to take Your Honour to in support of that. Now, the first one is a document, is the minutes of the fund's board meeting on the 27th of January 2020, and it's G2682.1.
Yeah, that's not, I think, in your note. What's that?
Sorry, it should be in my
No,
note.
the reference isn't.
Oh, I'm so sorry, Your Honour. It's G2682.1.
Yeah. Okay. So look. Yeah. I'll just have a quick look at that.
Yes. The relevant page I was going to take you on to is page 8. And paragraph 9.4 specifically.
We've gone into, I think, uncharted parts of the bundle, so it's just going to
Yeah.
2.6.
Yes, 2682.1. And paragraph 9.4 is what I'm inviting Your Honour to read.
Sorry, I'm getting dyslexic.
2682.1, page 8. Is Your Honour there?
Finally, yes.
So page 8 and it's paragraph 9.
Yeah.
So Your Honour, this is obviously prior to the onset of COVID. It's 27th of Jan 2020. And what is being reported by Ms. Menenzies there is that the fund has continued to and has delivered at that point 62 consecutive months of positive returns, achieving a cumulative net return to investors of 27.63%. Now, that's obviously a few months before COVID really hits. Now, the next document I want to take Your Honour to...
Well, yeah, it also depends upon the accuracy of the
monthly asset values and therefore the lack of write-offs and so forth.
Yes, well, Your Honour is right, but at least as at this point, i.e. 2 months before COVID kicks in, from ALAWWAL's perspective, the fund is continuing to generate positive returns by reference to the methodology, how it calculates it out. So
right.
the next document I want to go to is I-194. And this is what a fact sheet that was being sent to and communicated to the investors. And what I'm looking at, Your Honour, is the monthly net performance table at the bottom of page 1. Now, looking at the year-to-date performance figure, we can see that 2019 as a whole represents the best year of the fund in terms of its return.
Yep.
And ALAWWAL are obviously investors in the early part of the year. Now, if you look at the numbers there, and assuming for a second the numbers are all correct, we can see that throughout 2019, albeit it goes down towards the end of the year, they're fairly consistent. And again, it's consistent with the previous years. And we also see it on 2020. It carries on January as with December in terms of the monthly return. February takes a big hit, which is around the time COVID's becoming an issue, and then March is the sharp drop. So, and then if you look at May, April, June, July, again, that's right at the peak and the heart of COVID, where global economies were shutting down, and then we see some recovery coming out of it in August. So in my submission, that's consistent. What these reported numbers on a month-to-month basis show is it's consistent with COVID having been the effective cause of the drop in the performance of the fund, because it's no coincidence in my submission that the critical points of March to July, where the fund is performing the worst, that's when we all know from our own knowledge that's when COVID was at its highest. So say that explanation makes sense. Trade finance is obviously contingent upon supply chains, and COVID shut down all the supply chains. It shut down all the ports, at least for the first few months. So we say that's where COVID would have had a significant impact and an affected the performance of the fund. So in light of that, what I say is that the predominant or effective cause of ALAWWAL's loss is COVID, and that's why we say its claim must fail for that reason. And I've referred to the relevant part of Cartwright in my note.
Yeah.
Now, finally, what I want to deal with is the third heading, Your Honour, which is the claim for the loss of investment opportunity. And I think Your Honour had a back and forth with Mr. Adair about this.
Yeah,
about
well,
what my position would be.
as I understand this issue, it's a factual issue, first of all, and your case is that the two funds in play were AGC and the RASMALA fund. Mr. Adair's case is that it's the, whatever it is, the DEMIR, what's it called, the
Derived fund.
Derived fund.
Yes.
And you say, as I understand it, the evidence doesn't support Mr. Adair's case, and he says it does.
I say two things, Your Honour. The first one, Your Honour, is, as always, with me and one step ahead, which is the evidence does not support investment delay, and if anything, it points to the opposite end. But the second point is much more fundamental, which is ALAWWAL and my learned friend are asking you to come and make an assessment of what the opportunity loss is. What are they basing that on? What evidence does the court have before it to make a determination of what those other funds actually delivered? and therefore what is the opportunity that's lost. 6.5% is said in respect of Diraya Fund. It's Mr. Ali Ibrahim's witness statement. There's no documents to support that whatsoever. In respect of AGC, no documents in respect of that fund, but what we do know is he says AGC lost minus 5% over COVID, and he says we lost minus 50. But again, it doesn't matter if Your Honour makes a finding that, okay, you wouldn't have invested in Diraya, you would have invested in another fund. Your Honour doesn't have the evidence.
Right. Okay, so I understand both points. If I were, sorry, do you have a positive case that absent investment in this fund, the claimant would have invested in AGC? The reason I ask is this. It seems to me that the ordinary, sorry, I don't want to put it in an unfair way, the ordinary consequence of a claim for misrepresentation is that you get put back in the position that you would have been in at the time, and you get interest from the time which you put in. And that's the ordinary consequence.
Yes.
And it seems to me that's the ordinary consequence of Mr. Adair's case failing.
Yes.
But if AGC would have lost money as well, that may be a basis for something else, and that's why I'm putting the question to you.
Well, I haven't pleaded a positive case on that, Your Honour, and it's difficult for me to set out a positive case on that, because it's obviously the claim that's being met. What I can say is that it's open to Your Honour to obviously make that finding on Mr. Adair's case as to whether they would have invested in another fund. However, the evidence you have before you does not allow you, if you were to find that they would have, as to what their return would have been on that investment, and whether actually they would have suffered a loss. So in any event, we say the claim for an opportunity cost, whether Your Honour makes a finding that they would have invested or not, falls away. It comes down to nil.
Okay. I mean, look, I'm not stopping you. I think I understand where the battle lines are and what your points are.
Yes. Well, Your Honour, those conclude my submissions, unless I can be of further assistance.
No, that's very helpful, very clear. Thank you very much.
Thank you.
Mr. Adair. Mr. Adair, just to help you, we are, I'm afraid, going to finish. We're going to break in 10 minutes for about half an hour, and then we're going to come back. Well, I say about half. We'll come back at 3, and then we'll conclude. So that's where we're going.
Yes.
Yeah.
I'm going to rattle through this quickly. I've got quite a lot of points, but hopefully they're short and sharp, and I'm drawing your attention to them.
Well, unless they're short and sharp and good, they're normally not very effective in their Let's go on.
Looking at a few of the documents, I would like to go, just while they're fresh in our mind, and I have them up on the screen, if we could go to back to that monthly performance graph or table that was at I1941.
Yeah, I've got it.
The point I think that needs to be made about that is we know.
Yeah, well, your point about this is this doesn't adequately reflect the true position. That's your point about it, isn't it?
Yeah, the 35 million had been defaults, and we don't see a flicker on the chart until we get into the COVID era.
Yeah.
So no impairments were taken, and all of a sudden it's all dumped and blamed on COVID. And so one can't rely on that. The other, whilst we're still talking about documents, if you could go back to G2051, page 4, which was that suitability assessment, please.
Yeah. Yeah.
So if one actually looks at this, and if you're on page 4, and you look at under suitability, financial situation, the client is adequate capitalised and the financial situation is healthy. He currently works as a doctor at a hospital in Doha, Qatar.
That just so we're clear, that is the founder of ALAWWAL, who owns it. Mr. Malaka's father is a doctor. He's described as such in the witness statement.
The client has been investing in. That's not ALAWWAL capital.
Right. Well,
and it's not signed, so the status of this document in my submission is far from clear.
Okay.
Then what I would like also to deal with a little bit out of order is just this accountability of the fund manager, because a few things were said there, and while it's fresh in my mind, it was suggested that the way that accountability might work would be an unfair prejudice claim. That simply doesn't work at all. Unfair prejudice relates to the management of a company. It is between shareholders, it's an action between shareholders. If what we are talking about here is a wrong done to the company, and that can only be pursued by way of a derivative action. And because we have, in various common law jurisdictions now, we have a statutory derivative claim, the distinction between the two is important because you don't normally need the permission of the court, the leave of the court, to bring a unfair prejudice petition, but you do.
Need it for,
And so if you do for a derivative action, if you try and dress a derivative action up as an unfair prejudice petition, then you will be told to be you will be said to be abusing the process of the court because you're trying to circumvent the filter mechanism and the permission mechanism of the court. So it's important to maintain that distinction, and this is not an unfair prejudice situation. My learned friend said the other way was through articles of association, a claim via the articles of association. There is nothing in normal articles of association that allows a shareholder or a group of shareholders to sue the directors or anyone.
I mean, all of the points,
Yeah.
the points you're making all go to how odd this language of legal accountability is. But what's the conclusion?
Well, the point I think comes to this is there is absolutely no difference between the position of the directors of the fund or the position of Ribble. The directors of the fund, through the mechanism of the articles, the mechanism of derivative action, are no more accountable to the unit holders than Ribble is. Now, we can call Ribble, and it's almost certainly the case because Ribble was certainly managing the fund. I think that is a good basis for saying that they were a de facto director. But if the unit holders are the shareholders that hold anyone accountable for the mismanagement of the fund, that would only be done via a derivative action, so they could sue a director or they could sue Ribble because it was carrying out those functions. It doesn't really make much difference. The best description and the best way of rationalising it is that Ribble was a de facto director. But you don't sort of get there by saying, aha, therefore, as a de facto director or as a director, there is some article of association, because I've been through the articles. Certainly, on my reading, a fairly swift reading, but an informed reading, it didn't seem to me that there was any certain provision in the articles of the memorandum that circumvented the normal common law, that circumvented the rule in Foss and Harbottle, that circumvented the rule against recovery of reflective loss, Prudential and Newman, and allowed that accountability other than through that. I think if my learned friend was looking at the duties of the fund holder, which I think it was at 22, I think, Article 22, and that talks about them holding the fund manager having certain duties in terms of the management of the fund, etc. Now, those may be the basis of some form of accountability, but there's no direct, it's the thing of accountability. There may be some, but that depends upon who is the fund manager. And so, actually, although you've got A and B is the second, and B is the issue of fact, B probably logically comes first, and you say, who is managing that fund?
I mean, look, I really struggle with legal accountability.
Yeah.
But what I think it comes to, well, on the one hand, it's very odd, particularly in a regulatory context, to have a subparagraph which talks about legal accountability where it's very difficult to see what it means. But I think what you are saying as a consequence of that is that you almost disregard that subparagraph and read it if it was there. I mean, I think that's what you're saying. I'm not saying it's impossible, but it's an odd provision. It's an odd consequence.
It's a very badly drafted provision because it makes absolutely no sense. Your Honour is scratching your head. Mr. Beru is scratching his head, with the greatest respect to him. I'm scratching my head. So there's a reasonable amount of legal experience here, and we can't work out what it was intended to mean. It has to be a purposive construction. It's badly drafted, and so one has to say, actually, this is really governed by B, and everything flows from B, and then if we have B, then we do have some method of accountability, but on that basis of B, I think. Again, on these short, sharp points, just want to be clear regarding this idea that the offering memorandum is somehow a term or contains conditions or terms of the investment. I deal with this at paragraph 61 to 63 of my outline submission.
I mean, I think I've got your contentions in relation to that.
Yeah.
I mean, for what it's worth, I didn't see that the way Mr. Berry was putting it was really stressing these were terms, but anyway, I mean, sorry.
I think what my concern about it, why I flagged it, so we went to 1921,
yeah,
and he puts that's F192, I think, isn't it? Yeah, F192, and he put some reliance on the fact that it says Mr. Malaika has signed to say that he's received and read the prospectus, fine, and understood the terms and conditions of the above-mentioned fund, and our agreement to the terms and conditions of the fund.
And for what it's worth, I think I know what the battle lines are.
Yeah, my point is just that the offering memorandum is not the terms and conditions of the fund. They're the memorandum articles and the material contracts. That's the point. So I'm now going to sort of quickly work my way through, insofar as I have time, various, in the order that my learned friend has made.
Well, look, we're going to break now. We're going to break not for 10 minutes, but for half an hour, and we'll come back at 3:25 past. And
how long are you anticipating that I will?
Well, I'm hoping that you'll finish as soon as possible, but I don't think I can realistically cut you short by any earlier than the extra 20 minutes that you're being put forward.
Well, I was going to say, I sort of banked on having an hour. I may not need it, and I will try not to need it.
Particularly in Ramadan. I'm sorry about this. It carries out about, but I mean, there obviously comes a point when we're going to have to finish. But
of course.
You will make up the lost time.
I'm grateful.
If necessary. Yes, Mr. Stewart.
Your Honour, dealing first, I'm going to sort of steer you through these submissions, if I may, by reference to the outline submissions of my learned friend.
Yes.
So we know where we are. I'm looking now at paragraph 7 of those, which is dealing with the oral suitability representation. And the suggestion was that we can't run this case because we hadn't pleaded any reference to any assessment of suitability carried out by investment professionals at Ribble. The position is that their pleaded case, pleaded all over the defence, is that this was a high-risk, highly speculative investment. By way of example, paragraph 8.3, 22.1, 23.2b1 and 2, 34.3, G, 45.2a and 71.3b. It all says high risk. That's their case. That is what they say in the offering memorandum. So what the oral suitability representation constitutes
is effectively a statement in this context that it was suitable for ALAWWAL on the basis that ALAWWAL had stated what their investment objectives were. And so the first point to make is that there was never any challenge, as I've already said, to Mr. Al-Ibrahim's evidence that at the meeting on the 14th of November, he explained that the investment objectives were low risk, Sharia compliant. So the suitability representation is a representation, effectively, this was low risk and Sharia compliant. It's as much as that. My learned friend sort of branched off to start saying at various times, well, this is all relative risk. So, but they haven't, their cases, this is high risk and highly speculative. There's been no issue about the relativity of that risk, etc. And all the witnesses were fairly clear, the professional people, that this was categorised, they said, as on the Ribble side as high risk and highly speculative. And Mr. Al-Ibrahim was fairly clear on what constituted a low risk, as I think was Mr. Swat. So the suggestion that you cannot run this case of the oral suitability representation is misconceived. If, as on the basis of Brown and Dunn, there must be, in my submission, a finding that Mr. Al-Ibrahim did explain the ALAWWAL investment objectives, there must have been a response to that. And that response was, yes, this is suitable for you, which is effectively a representation, this is a low-risk investment, which is Sharia compliant. I'm now moving on to paragraph 13. And there was a submission, which in my submission was surprising, that Mr. Al-Ibrahim and Mr. Malaika were both very highly unreliable witnesses, was the way that was put. In my submission, that's not a credible assessment of their evidence. One of the reasons is that they contravened, it is said, the DIFC rules 2918 about the way that a witness statement is written. 2 points on that. One, if that is the case, then that is something that ought to have been brought up before trial and challenged then. But in any event, it doesn't go to the honesty of the witness or the reliability of the witness, how their witness statements were actually put together. There are a number of suggestions of Mr. Al-Ibrahim's evidence being unreliable because he suggested low to medium should be interpreted as low risk to the beginning of the range of medium risk, which was plainly not the words meant. None of that shows an unreliability in terms of the factual evidence he was giving. It was quite clear he was being honest and straightforward. At the bottom of that page, so it's this paragraph 13.3c, there is reference that no investor would build his investment decisions based on or rely on an offering memorandum. And Mr. Al-Ibrahim is supposed to have effectively said that. Oh, sorry, that is supposed to be contradicted by emails. And you're given a reference 69.2. Do look at that. Well, I think it might be worth just looking at that if we can go to it, 69.2. Because F69.2, what it says there is it's Mr. Al-Ibrahim saying, we're interested in your trade finance fund which generates significant returns. We'd like to know more details about it, such as prospectus, fact sheets, flyers, and any relevant material you can provide us in order to build our investment decision based on. That doesn't, in my submission, tally with what my learned friend is submitting. It does. If I move on now, over the page.
I mean, Mr. Depp,
Yes.
I've formed my own view of the witnesses generally. I am going to go back and look at specific examples
Yes.
in relation to them. I'm not stopping you saying anything about
Yes.
any of this one way or the other, but my own experience is that, on the whole, judges aren't all that. They tend to form their own view about the witnesses, and if people have got specific points, they'll of course take account of it. But as I say,
No,
I'll leave it in your hands.
I went to that document because it was an extraneous document.
Of course.
And in terms of the assertions that are being made, I will just give you a couple of references that I think are relevant to the points that are being made,
helpful.
but I'm not going to take you there. Because at, I think it's paragraph 13(4)(b), it's asserted that Mr. Malaika refused to accept that
He didn't attend, etc.
yeah, he didn't say blah, blah. I don't think that's correct, and I think if you could read day 3, page 115, line 13, to page 116, line 11, that may be enlightening on that particular issue. Then I'm moving on to paragraph, well, it's just above paragraph 14, and it suggested that he refused to answer basic questions. And the reference there, when you actually go there, he says, I honestly don't know how to answer that question. And that's what he says. That's not in my submission when you read it, a refusal to answer questions.
Yeah.
Now, this adverse inferences, I just want to make a couple of points about that.
Yeah.
Mr. Lomonaco, the only argument in respect of him was that he was dealing with different issues, but he was an investment professional who attended the meeting on the 23rd of January and the meeting on the 6th of February. So he was there as an investment professional who would have understood exactly what was said and was in a position, still employed by Ribble, to give helpful evidence potentially to the court as to what he recalled having been said on a number of important issues. No explanation has been provided for him not attending, and there is no explanation because he's still here in Dubai and he's still employed by Ribble, and they could have required him to come to court as part of his duties of employment. Mr. Zographos, there is, notwithstanding my learned friend's attempt to give evidence during the course of his submissions, there is no evidence before Your Honour as to why he is not attending. And that is relevant, extremely relevant. I mean, the only thing that was said was Mr. Swat's in brackets in a paragraph of his witness statement said, as far as I'm aware, he's no longer in Dubai, and it was put to him that he's actually in Abu Dhabi. He's still in the Emirates, and he said, I don't know. What I do say about that is, when you look at the ALAWWAL case, to which my learned friend, on which my learned friend relies, what all these cases say is what is important is the explanation that is given. And there's two things. One, we must advance some positive case, and two, if the other side are trying to rebut some inference being borne, they must give an explanation. And in the absence of any explanation, in my submission, Your Honour is entitled to draw adverse inferences from that. And on both of those, Lomonaco and Zographos, there is no explanation before the court at all.
Well, without wishing to prolong this, we do positively know he's not employed.
Yes, we do. That's accepted, yeah. As is Mr. Bitcon, no longer employed.
Yeah, but we know he's no longer employed. It's very commonly the case that witnesses who are no longer employed are unwilling to give evidence voluntarily. I mean, not universal, but very commonly. Now, what inferences do you say I can draw from that? The inference you want, I think, is that his evidence would have been adverse to.
That's the inference I would ask Your Honour to draw. Yes. Yeah. And I recognise that it is common when someone is not employed that they don't want to get involved anymore. They've moved on with their lives. Why would they want to come back? I understand that all. But then it behoves the party who is not calling them to provide an explanation.
But a possible alternative, and the possible alternative is that the inferences are that he's not willing to come voluntarily, and the defendants aren't willing to take the risk of
Subpoena.
Of subpoena.
Yes. I mean that's all wrapped up with it. If he is within the jurisdiction or within a jurisdiction where it would be possible to enforce some subpoena, then they didn't want to do that. So yes,
Okay.
my submission is that the main point is there is absolutely no explanation at all, and on that basis there is nothing to rebut the inference that we're asking you to draw. Then there is, moving on, oral representation. Points are made regarding the 23rd of January meetings, and it said that this was not an agreed statement. A big, great story is put on the fact that it wasn't circulated. It wasn't a document that was circulated. Your Honour, this case has no contemporaneous documents really in relation to any of the meetings except for this one. This is your one contemporaneous document. And in my submission, it's an important document because whilst, yes, I accept it wasn't circulated and Ribble didn't sort of sign it off, it is a contemporaneous note of what those at ALAWWAL who had attended the meeting understood to have been said, and it is their conclusions that they drew on the basis of it. And you can then follow that through with the decision that was being made, or decisions being made and conversations being had in the Business Development Committee. So in my submission, it is important, and to say, oh, well, it wasn't agreed is a somewhat tenuous basis to try to cause you to put less reliance on it. Now, these are all attempt to characterise all of these meetings as just being general, generic marketing, etc., etc. You know that no one was entitled to rely on them. In my submission, you can't characterise 4 successive meetings as being all general, generic marketing meetings where salesmen were engaging in puffing up the investment. That doesn't work. It also doesn't work because the 6th of February meeting, Mr. Bitcon expressly accepted in his evidence, and I think you'll find that dealt with at paragraph 43 of my outline submissions, that this was part of ALAWWAL's due diligence and that he was expecting them to ask questions. Now, as far as the 6th of February meeting is concerned, my own friend didn't actually address the Brown and Dunn point specifically in relation to that meeting. He addressed it more generally. My submission, that is where it is most serious and where it is most important. Because one, Mr. Malachi says, I explained to everyone the ALAWWAL investment objectives, i.e. Sharia compliant, low risk. But he also says he asked specific questions about defaults that would affect the performance of the fund. Now, he was not challenged on. I've set that out in my outline submissions. Mr. Biru has not suggested to the contrary. If that is the case, then that drives what happened at the rest of the meeting. Because if everyone was sitting in that meeting in full knowledge that all that ALAWWAL was interested in was low-risk Sharia-compliant investments, then that is important and begs a number of questions. It's even more important if he did say to them, are there any defaults that would affect the performance of the fund? Because we know that there was $35 million worth of defaults, which would have a profound effect on the fund. And that means that there must have been some answers given. And so the suggestion, oh, there were no questions, well, that goes by the wayside. And the suggestion that that we never said what Mr. Malaika says that we said, again, is very difficult, because if he specifically asked about representations that could affect the performance of the fund, then that's in line with what he says the answers he got to that question were, and the representations that were made. And my submission is that in those circumstances, there has been nothing in the evidence to rebut that. As a combination of the adverse inferences, the failure to challenge the evidence, and the fact that Mr. Bitcon and Mr. Swats, by their own admission, can't remember what was said, in my submission, Your Honour should find that those representations were made, the default representations. Moving on to paragraph... yes, I wanted to say something more about Brown and Dunn, actually, because my learned friend said, oh, well, it's been watered down, the Chewy case in the House of Lords. 2 points about that. In my submission, it's not the case that you now don't have to challenge evidence and you don't have to put your case to a witness. That, in my submission, the position, if you are conducting a trial in England, is the same as it's always been. But we are not conducting a trial in England, and it's not English common law specifically that applies here. And funnily enough, the rule in Brown and Dunn is somewhat stronger in Australia and somewhat stronger in New Zealand. As far as I'm aware, it's been codified in New Zealand. And possibly the case of Brown and Dunn is better known there. It's less known in England because of the somewhat obscure reports that it appeared in. I know sometimes you say to quite experienced practitioners Brown and Dunn, and they have no idea what you're talking about. But if you say that to an Australian, they will immediately know what you're talking about. So if we are dealing with the common law here, rather than English common law, I don't accept that Chewy has necessarily watered down, but even if it has, and my learned friend is right, that's not the position that is binding on Your Honour when you are dealing with the common law and looking to all the common law jurisdictions for guidance on this. And if you look to Australia or New Zealand, you will see a very strict application of that particular law, of that particular rule. Now, I'm moving on to paragraph 17 now of my learned friend submissions, and this is the oral multi-layered representation, and Your Honour took him to where that was pleaded at paragraph 29.2, and said, well, you know, that makes sense, doesn't it? And suggested how it might, proposed how it might be interpreted. My learned friend's rather trying to have his cake and eat it, because at one point he says, at his opening, he said, well, Mr. Adair has to prove all the master representations, as he has called them. And then when Your Honour found, or suggested, as merely playing devil's advocate, that master representation must be made out, oh no, well, if you then have to go and look at the underlying foundation representative, well, you know, he's got to decide what it is. And what the master representations essentially set out is how those representations, the foundation representatives, were understood, and how their cumulative effect must be understood as well as being their individual effect. So the point there is you can't have it both ways. The idea that is fundamentally inconsistent with the nature of trade finance. My submission, the fact that this is Sharia trade finance, does actually narrow it down a little bit, and I think Your Honour made reference to this, that if it is properly Sharia trade finance, there must be some underlying goods that are being sold at different prices. So that actually, in my submission, narrows down the type of mitigation practices that can be employed, etc. And it undermines the point that my learned friend is going to make, is that the trade finance is so varied that you couldn't possibly, that representation just wouldn't work. As far as the point that is made at 17.4, where it is suggested that Mr. Al-Ibrahim said or confirmed that he did not consider that this was something they should rely I would ask Your Honour to go to and read day 3, page 60, lines 5 to 9, and also page 1, also day 3, page 162, line 20 to page 163, line 16, when you look at that point. Going on to paragraph 19 and the fourth oral representation, the 0% representation. This was said in those terms. There is no evidential basis to contend otherwise in my submission. The context in which it was made was that there were $35 million worth of defaults, and the way and ALAWWAL had set out their investment objectives. So the way this has to be understood and interpreted was this is a very low risk investment. It is sort of a little bit of hyperbole and to say 0%, but the way anyone would understand that, no one here, an investment professional, is going to understand that as being literally 0%. They would all understand it is a representation, it was low risk. Moving on to paragraph 20, fifth oral representation, or suitability representation, and subparagraph 3, it says the representation was not made, and I think at B.
Sorry, just before we go on to that,
yes.
can I just raise one point which the representations are being made at the series of meetings and documents between January and
between
February.
November 2018.
Sorry, November and
February.
In February of 2019 to 2020.
No, 2018 to 2019.
Yeah. Let's just take 0%.
Yes.
And let's assume that you're correct to say that that needs to be read not as being literally 0%, very low risk. Let's say that. Now, that's a reference. It's on your case being said in relation to the purchase of units in a fund in the early part of 2019. Now, you presumably say that takes into account all the facts known as at that point.
Yes. Which is why I said 35 million default, etc., etc.
Yeah. I'm just thinking through the. So you would say, if the only reason why that was untrue was because there were 35 million of what you've described as being defaults,
Yeah.
then, as it were, you get home.
Yes.
Even if at some earlier stage, the beginning of 2017, it could legitimately have been described as low risk because by that stage there hadn't been any defaults.
Yeah. Yes.
Okay.
Yeah.
Right.
No,
I understand how you put it.
Yeah.
All right. Sorry, I interrupted you.
So I've just gone to paragraph 20, representation, fifth oral representation, oral suitability representation, and at sub-paragraph 3 he says representation not made, and then B, evidence demonstrates that ALAWWAL's investment objectives were not limited to low-risk investments. I'm not sure, in this context at least, that argument is open to Ribble in terms of what was said at the meetings, on the basis of the failure to challenge Mr. Ali Ibrahim and also Mr. Malaika on their explanation of the ALAWWAL investment objectives. It is, in my submission, clear that what was said to Mr. Zografos and what was said to the attendees at the 6th February meeting was that Sharia-compliant low-risk investments. even if, and you know, my own friend is quite right when he goes wider and says that in terms of behind the scenes, business development committee was looking at, and the planning was on the basis of low to moderate risk, and there is reference to moderate risk. But that doesn't mean that they hadn't decided. They were talking to Ribble on the basis that they were looking for low risk investments, and that is what they told them they were after. And in that regard, obviously, it's the failure to challenge paragraphs 15 of Mr. Ali Ibrahim's witness statement and paragraph 23 of Mr. Malaika's. And I do stress that Ribble, and I gave a list of the various references in their defence, have always said that this is a high-risk, highly speculative, that's their case, high-risk, highly speculative investment in the fund. Moving to paragraph 22, the oral default representation, and this is the one where, in my submission, Ribble runs smack bang into the lamppost, which is the failure to challenge paragraph 23 of Mr. Malaika's witness statement, because he asked those questions. They have not suggested otherwise. Therefore, there must have been answers given to those questions. And also that rather undermines the position of the evidence that's given by Mr. Bitcon and Mr. Swartz.
Sorry, what underlines it?
I mean, their evidence was, I don't remember, but we wouldn't have said that.
Sorry, yeah, okay. I understand what you mean. That's what I was, yeah.
So I'm now moving on. Well, I think then the point is just sort of keeping on that, the oral default representation. 4 points are made at subparagraph 4 as to why those representations, the oral default representation, were made. And in my submission, in those circumstances, they all fall away. Moving on to the written representations, again, there is this desire to portray everything other than the offering memorandum as generic marketing documents. In my submission, that simply doesn't work. There's 2 reasons for that, and it's the 2nd of January exchange of emails is the first and foremost. Now, it's important, I think, to look at the evidence of Mr. Ali Ibrahim when it was put to him, because I think my learned friend's pointing there, oh, when you go, and he took Your Honour to those emails, and he said, well, if you read it, it's talking about the companies, and there they must have been intending to mean Ribble's. Now, no explanation is given as to why ALAWWAL would have been remotely interested in what Ribble's risk mitigation measures might have been. And that was the point that was made very firmly by Mr. Ali Ibrahim. And with all Mr. Ali Ibrahim's evidence, because of the language difficulty, it goes around the houses a little bit. But ultimately he said, why would I have been remotely interested in Ribble's? I wasn't acquiring Ribble, I was acquiring an interest in the fund. I wanted to know what the fund's risk mitigation measures were. And Mr. Ahmed and we both knew what we were talking about there. So the suggestion that I think the way my learned friend put it was that Mr. Ali Ibrahim accepted that was a possible construction. I mean, what Mr. Ali Ibrahim said is we both knew what we were talking about. I wasn't interested in Ribble, I was interested in the fund, and that's the answer that I was given. That's the only explanation of that exchange that makes any sense. I mean, the best place to see it is, I won't take you there, Your Honour, but it's F110, as I remember, where you see both of the emails. You see the response from Mr. Ahmad, and you see the request from Mr. Ali Ibrahim.
Yeah.
once you say, we understand that that RFP was provided in the context of that exchange, it takes on a different complexion. I mean, it can't possibly be just a generic general marketing document for general information purposes, because it was provided in specific response to a specific question regarding risk mitigation. And that is why we say, and I've previously said in my outline submissions and my own initial opening, that negated the disclaimers. I'm moving on quite a big chunk to paragraph 28, which is the fifth written representation, the written low-risk representation. In my submission, this is important. And it says, as Your Honour saw when my learned friend took you there, that that the fund had a conservative risk profile. It was a low risk. It was a clear statement, and this is a very important written statement. Now, my learned friend said, "Oh, well, this is all relative. What's high risk for some people is low risk for others." But everyone knew what they were talking about here. There was no sort of, it wasn't a case that what Ribble regarded as high risk, ALAWWAL regarded as low risk. There was no cross purposes here. Everyone knew what each other were talking about, and Ribble has been clear and has pleaded that this was a high-risk speculative investment. But in this particularly important document that was provided specifically in response to questions about risk mitigation, it said conservative risk profile. So, I mean, I think, summarising on that, both sides of the litigation are experienced professionals. They both understand what is meant by low risk and high risk. That application form that was completed demonstrated that, where ALAWWAL ticked medium and low risk boxes. Ribble wrote in the offering memorandum highly speculative, but then they also wrote the RFP, which was inconsistent with that. RFP, inconsistent with the offering memorandum, negated what was said in the offering memorandum and coincided with the oral representations that were being made. Now, on the reliance point, it was submitted that it's not reasonable for ALAWWAL to rely on what was written in the documents or what was said to them in meetings, because they were carrying out their own sophisticated investor and they were carrying out their own due diligence. You cannot carry out due diligence on any investment unless you are provided with accurate information. And if you are carrying out due diligence and you ask specific questions about defaults, etc., or risk levels or risk mitigants, then you're entitled to get truthful, accurate answers. And you cannot then, the person giving those answers can't turn around and say, "Oh, you're not allowed to rely on those answers." That simply doesn't make sense. And to suggest that due diligence is a purely unilateral rather than a bilateral operation is in my submission wrong. On the subject of actual reliance, which my learned friend deals with at paragraph 32, he says, on ALAWWAL's pleaded case, it reached a settled decision to invest in the fund by the 2nd of January. And that was our pleaded case. I sort of stood up and interrupted my learned friend on the only occasion, I think, during his submissions, because actually, if you go to...
Twice, actually. Once you also said something wasn't signed, but anyway.
Oh, I think I asked a question about why was it signed. I think I didn't know where I was. But,
I was teasing you.
To be fair, okay, but maybe twice. So our pleaded case was subject to completion of due diligence.
Well, I mean, there are 2 points about this. One can argue about what your reply meant, but secondly, in the context of this, it seems to me that
finding that this meant that you couldn't rely on anything after that, if otherwise you're entitled to, might be thought to be a bit of a stretch. But anyway,
Yeah.
might be another way of putting it, that my present view, which might of course change, that Mr. Beery probably has got better points. But anyway.
Yeah, sure. And we do know that everyone understood, Mr. Bitcon certainly understood, that the 6th of February meeting was for due diligence purposes and that questions were going to be asked. The RFP was provided on the 7th of January on the basis that it was for our due diligence purposes, so that we could look at risk mitigation. So the argument then becomes that we had made our decision on the basis of our own assessment of standard deviation, I think was the way that my learning friend, he went to that sort of assessment that was carried out, where the fund's deviation was analysed, etc., and the conclusion was got to the RASMALA, the RASMALA fund, trade fund, the fund was one of the low risk ones. And he says, well, they made their decision on that. They weren't relying on any other representations or anything else. But that, if you test that, if Mr. Malika had been told in answer to his question, oh yes, actually there's $35 million worth of defaults that we're sitting on at the moment, and he said, what, 10% of the value of the fund? Yes, he wouldn't have invested in that fund. And if they had said, oh yeah, by the way, this is a high risk, highly speculative fund, not a low risk one, he wouldn't have invested. That would completely cut across the reasoning that you see in the Business Development Committee minutes. The two relevant committee meetings for that purpose were on the 24th of February, which one finds at F173, and the 17th of February, which one finds at 169. And they're both looking at the fact that it is low risk. That is what is dominating their minds.
I mean, how do you deal with the fact that in the offering memorandum, it does, in a particular place, say that investment in the fund was highly speculative, involved substantial risk. So how does that square with that?
Well, I think the way it squares is that it was effectively negated by all the other information that was provided. That bit of information was effectively crowded out by repeated statements, oral representations regarding the low risk of the fund and its suitability for ALAWWAL, and with the written representations in the RFP, which were in response to a specific request about risk mitigation. So when we asked about risk, we were handed the RFP, which said it was a conservative risk profile. So you cannot, Ribble say we can rely on, they knew it was high risk because we said it in that document. You can rely on that, that's your consistent message. But if actually you're saying different things in different documents, and orally, in oral representations, you're saying this is low risk and this is suitable for you, do invest in this. And if at the same time the suitability assessment that was necessarily being carried out as a part of the compliance says yes, no problem, and on you go, notwithstanding ticking of boxes for moderate and low risk, and this is high risk, then in my submission that cannot be relied on. That has been negated, crowded out, the noise is being too great going the other way. If Ribble are going to rely on it, there has to be a consistent message that they're making.
Well, or do I have to come to the conclusion that looking at all the information provided, some written, some oral, some in response to specific queries, some not, possibly different things even said within different documents, for example, the offering memorandum and so forth, that a investor in the position of your clients, being a sophisticated investor, did and could reasonably have taken the view that the investment was low risk.
taken that view on the basis of the representations that were made to them.
Well, of all the information.
Yeah, yeah. I think that's essentially when I'm saying crowded out, the bulk of the information that was coming to
I mean,
them.
at the moment,
Yes.
that's how it seems to me I have to approach it. And I'm not saying it's impossible, neither am saying that,
Yeah,
saying that
sure.
it's possible, but it seems to me that one has to look at this matter
In the round.
in the round, by reference to, on both sides, the plum and the duff.
Hmm. Well, that's certainly how I would submit it works, because the Ribble is saying, well, look, because we had this one line in our offering memorandum,
No, no,
that's our get out of jail free card.
And
you
the
know.
question is whether or not that's a. Well, yeah, I was about to make a metaphor, but I don't think that'd be helpful. All right, right. I've got how you put it.
I'm grateful. So, moving on to the disclaimers, I don't think there's much that I need to say about this that I haven't already said, and I'm not going to just make those points again.
Yeah.
Except for one. I don't think my learned friend went and took you to Rule 3.2.2 of COB, or made any submissions to you regarding what the effect of that was as far as the disclaimers are concerned, even when he was, as far as I can recall, and I might be wrong, talking about the regulatory claim.
If it assists, so we don't dispute the fact that you can't exclude liability if the DISA administered legislation under COB.
But that's helpful, thank you. So, I mean, that is, in my submission, in terms of the regulatory claim,
Yeah.
that is important.
Yeah.
Now, cutting to the chase on this, I think the key point that I have to address you on here is, in terms of the regulatory claim, that's what I'm moving on to now, 3.2.1, which is to take reasonable steps to ensure that communications were clear, fair, and not misleading.
Yeah.
My own friend says, oh, well, it's only an obligation to take steps, and we clearly did that. My submission is if, in the case of a high-risk fund, you say, this is low risk and it's suitable for your investment needs, etc., and where there are $35 million of defaults, you say there are no defaults likely to affect the performance of the fund, you haven't obviously taken reasonable steps to ensure that what is said is clear, fair, and not misleading. The other particular provision which I need to address you on is 56.2 of the collective investment law. I don't know if we could go to that.
Can you remind me of the reference?
I will. I think it's E14, as I recall.
Yeah.
Collective investment law. And
36.
36, thank you. Thank you. And 36, my learned friend is assisting me with my references then.
E14, page 36.
Page 36, ma'am.
Yeah. Yeah.
Sorry, it's taking me a while to scroll there. And so the provision we particularly rely on, as I made clear at the outset, is 56.2. A person shall not, in or from the DIFC, make a misleading or deceptive statement in relation to a fund or in connection with an offer of units, whether in the DIFC or elsewhere.
Now, my learned friend's answer to that is to say, this is misconduct, and therefore it doesn't cover negligence or mistake, it is only deliberate. Now, whilst I think he has a reasonable argument on that, on 41B of the regulatory law, in my submission that is wrong as regards this. Because there is a clear distinction between misleading or deceptive.
Yeah,
Deceptive.
I mean, you would say that the language is different.
Yes.
And this might be said to mirror, misleading could be equivalent to negligent misstatement,
Yes.
innocent misstatement, or indeed fraudulent misstatement. Well, not fraudulent because the word's deceptive,
Yeah.
but it could be innocent or...
Innocent or negligent. And I think one gets that if one then goes down to 57, which talks about defences to this particular provision. And so it says a person does not commit a contravention of Article 56 if that person proves that he made all inquiries that were reasonable in the circumstances,
Yeah.
and after doing so believed on reasonable grounds that the statement or omission was not misleading or deceptive. And then person does not contravention if that person proved that reasonable reliance was placed on information given to that person. Now that isn't any suggestion there of fraud.
Yeah.
It is a negation of negligence as
Yeah.
much as anything else. So in my submission, that doesn't, my learned friend's case doesn't work on that. That this is, it can obviously be fraud, deception, but it can also be innocent and negligent.
Yeah.
And that's, I think that tallies with also what is 3.2.1, this sort of clear, fair and not misleading. And misleading is a term that is used throughout the DFSA administered legislation. And clearly in 3.2.1, clear, fair and not
Yep.
misleading, that doesn't
Yep.
entail fraud. This causation and loss points that my learned friend made, and again I think he came back to this, well, there was no reliance on any of the representations, they made their own assessment. I think if you go through the Business Development Committee minutes of ALAWWAL, you see that reliance was placed, and one can follow through these threads as one follows through the chronology from the minutes of the 23rd of January meeting, from the feedback on the 14th of November meeting, the report in particular that comes after the 6th of February meeting from Mr. Malaika, which particularly dwells on the importance of the fact that this is a low-risk investment. And when one looks at all of those, one can only come to the conclusion, that would be the approach that I would urge on Your Honour, to look at those Business Development Committee meetings, minutes. And it's quite clear that there was reliance placed, and there wasn't a decision that was taken completely separate and distinct from the representations that were made, both in writing and orally. Sorry, that's all I want to say about reliance. I'm just backtracking because there's something else I wanted to say about the regulatory claim. And it's just a summary point, really. If you're with me on 3.2.1 and also on 56.2, and it's been admitted that 3.2.2 clears the way of all the disclaimers, and no point is taken that the Regulatory Law Article 94 doesn't apply, in my submission there is a clear path through on the basis of this claim, on the basis of both the written and oral representations. The clutter, as I think I said earlier, has been cleared, and that those claims must succeed. The final point that I would make, how we're doing, 1/4 past, is just on this opportunity cost and the Deraya fund versus the AGC fund. And the suggestion is being put that it's quite clear on the evidence that all that money would have been put in the AGC fund and you'd have lost it. If you look at two documents, I won't take you there, but there is I think a teaser or a document at F56, and also one F41, page 3, which made clear that that fund had a diversification requirement, and the idea that they could, in those circumstances, pile all the money into the AGC fund, where there was a stated intention to diversify amongst trade funds, is in my submission obviously wrong, and that in those circumstances, on the balance of probabilities, Your Honour should find that the money would have gone back into the Deraya fund.
Good.
Unless I can assist Your Honour further.
Thank you very much, Mr. Stewart. First of all, I'd like to thank the parties for everything they've provided. I'm not going to give judgment at 10 o'clock tomorrow, and I will reserve my judgment and give it as soon as I can. Thank you all very much, and thank you in particular to those who organised the documents, and also to the transcriber, who I can't see but has done an excellent job. Good.